Lordship, with the consent of other side, I beg to mention item number 7, my lord. Arguing counsel, Mr. A.K. Bura lost his father, my lord. He is in
It is
bereavement,
submitted
my
at the bar that the arguing counsel engaged by the petitioner in this case is in bereavement. Therefore, a prayer has been made to adjourn the admission hearing of this case for 3 weeks. Since the prayer is not opposed, same stands allowed. List accordingly. Yes.
my lord. After 2 weeks, any
My lord, item number 9, my lord, this matter relates to compassionate appointment. My lord. The series matter has been listed in court number 4. All the matters have been listed. So,
Today,
yes, my lord. Along with 5067.
Mr. N. Sharma, learned counsel for the petitioner, submits that since this is the matter relating to prayer for appointment on compassionate ground, and similar matters are pending before this court. Hence, this writ petition be tagged along with WPC number
5067 of 2024.
5067 of 2024 and the batch of connected proceedings. Prayer allowed, registry to do the needful.
May it please your lordship. Lordship, I beg to mention for listing of an IA for implement. Matter was to be listed on Thursday. Due to some defect, it could not be listed, lordship. For tomorrow, lordship. Because lordship, main matter is fixed on 27. We want to take steps before that, lordship. Lordship, another contempt petition, lordship. The Honorable Court had passed a direction for interim relief on 10th March. However, lordship, the District Commissioner of Moregaon District has outrightly rejected to comply with the order, lordship. And lordship, therefore, I pray that the contempt matter be allowed to be listed for tomorrow, lordship.
Contempt tomorrow not possible.
Lordship.
Next week.
Lordship, matter is listed on next week, lordship.
The contempt will come next week.
Lordship, on Friday, lordship.
Next week. You come
Lordship,
contempt next week. IA tomorrow.
Lordship, Monday, contempt.
What is the urgency?
Urgency is that, lordship, it's a petrol pump. Lordship, on 10th, lordship, the Honorable Court said that for 2 weeks, the petitioners can run the petrol pump as an interim relief. Matter is listed on 24th, lordship. Lordship, the interim relief will be infructuous in that case.
No, this is who has given you this idea? Interim relief will be infructuous.
Lordship,
Who is it? That's all based on wrong understanding of law.
lordship.
Contempt is not meant to drive home implementation of an order.
Lordship, but
Contempt is only meant to punish the guilty for non-compliance.
lordship,
If you want a urgent relief, then you file another IA. The court will pass an order.
lordship, on Monday, lordship, in this case.
Yeah, but you are making a request on wrong premises.
Lordship.
Monday, but it's a wrong request.
Deeply,
You must know it.
lordship.
This is not how the court system functions.
Deeply.
You ask your senior and you will know what is the mistake you have made. On Monday, what will happen? In the contempt case, you expect the court to pass an order for
Lordship,
implementing.
because lordship, the district commissioner, lordship, has threatened the petitioner.
Whatever it is, you
on
file an
person
IA.
capacity,
Contempt is on the violation of the court's order. That's all.
lordship.
That will be heard in due course. Nothing will happen on Monday on contempt case.
Lordship, happens
Get
on
it
Monday,
listed.
lordship.
Yes.
Deeply.
May I please your lordship? With the consent of the other side, I beg to mention item number 12, lordship. My senior Mr. S. Chauhan is not well, lordship. Kindly adjourn for the day, lordship.
On the prayer of learned counsel for the petitioner, hearing of this matter stands adjourned for 3 weeks.
Oblige,
Yes.
lordship.
Yes.
May I please, lordship? Lordship, I beg to mention for listing, lordship, on cooperative matters, lordship.
On
Cooperative matters, lordship.
listing
Yes, lordship.
after Bihu. Give it.
May I please, the lordship, with the consent of all other parties, I beg to mention item number 16. The matter may be adjourned for today and may be fixed on the April of 24, your lordship, or 29.
No, we can't give a date, but you are appearing for whom?
I'm for the respondent number 1 to 3, lordship.
I am appearing for the 4th, aspirant number 4.
And what about the applicant? No objection.
I have taken
Yes,
consent.
given the ground of inability of the senior counsel, lordship.
That's not a good ground. After Bihu, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, 6 adjournment in this case with a request to post the matter again after 3 weeks. Since the prayer is not opposed by the counsel for the applicant stroke petitioner, as well as the respondent number 4, the same stands allowed. Let the matter be listed after Bihu vacation.
Highly appreciate.
Yes.
May I please your lordship? Lordship, I kindly beg to mention item number 14.
Yes.
Kindly pass over the matter for this day as my senior PK Sharma has gone to Karbi Anglong for another case.
Has gone to
Karbi Anglong for
Karbi
another.
Anglong?
Yes, sir, your lordship.
How has he gone?
I have no idea.
You don't know. Where is he staying?
I might be in a hotel, I guess.
So you want a fixed date? Yeah.
Next week, Lordship.
That prayer is rejected. You want a high court to wait for your senior to do a case in Karbi Anglong? Huh?
That case was.
This is very sad. On the prayer of learned counsel for the petitioner, this matter stands adjourned for 3 weeks. Yes, adjourned for 3 weeks.
May I please, Lordship? Lordship, I beg to mention item number 8, Your Lordship. Lordship, we have filed affidavit in opposition, Your Lordship, on 12/3/2025, Your Lordship. Lordship, the affidavit in opposition not put up in the file, Your Lordship. Lordship, may kindly call.
No, we'll see. When the matter comes, we'll post it on another date.
Highly obliged.
Yes, Lordship. My lord, one cooperative society was constituted AGM by 172 false members, and it was inquired into by the inspector. He found that the entire AGM was falsely conducted by wrong voters, unknown strangers. So he cancelled the AGM and appointed one-man committee by zonal register. But the register, without considering the inquiry report, set aside the said order and asked this wrong committee to function. So matter is as we have already filed a case. Lordship may kindly put up the case tomorrow morning.
But it will go to the appropriate bench. This is a bench 5 matter.
No, bench 4 matter.
Bench 4 only up to 2020. Check the cause list. You must not have seen it. Mention is allowed, but before the appropriate bench, you write it.
May I please, Your Lordship, I beg to mention WPC 6269 to 24 for listing on Friday.
What is it? WBC 62C.
6269 of 2024. 2024.
What is the matter about?
Matter petitioner is aggrieved due not received of his pension benefits.
Second week of April.
Second week of
April.
I leave this.
Daily list for admission item 1 and 2.
Yeah, so many TV screens have been fixed. Yes.
No, this is the case where by applying 56J of the Fundamental Rules Central, the petitioner has been retired prematurely, who is a doctor, psychiatrist in the grade of associate professor in the Jasper Dr. Lokaprat Gopinath Bordoli Regional Institute of Mental Health. Yeah. There are 2 petitions. First, when 56J was applied and order was passed, we challenged this. This honorable court in that proceeding directed them to carry out a review, if so advised. They have done it. Placed that order. We have challenged that also. This is how the second lead petition. That's how I must say, only the review is different. Therefore, there. So here, before I take your lordships to the implications of the law, more particularly the 56J, I will submit that this is an order, or this is a step taken by the respondent concerned, the director, only to shortcut the process of punishment. Is a punitive nature actuated by malice and acted in a violation of the orders of this honorable court. He ultimately passed the order when he was asked to go on superannuation. Superannuation was issued that he is going to superannuate on such and such date. And thereafter, he approached this honorable court. This honorable court said that yes, there will be a stay order, but not with respect to the post of director. He may be in service because he claims that he should be allowed to continue up to the age of 70 years in the rank of professor. This honorable court said that that will be considered later on. You may continue in service, but not against the post of director. Taking advantage of that, he issued the order, the impugn orders here. If I take your lordship to those papers first, there were two departmental proceedings initiated against me. He put me under suspension first on some ground that certain papers were leaked out from the office and I may be the culprit. I challenge this before this honorable. This honorable court ultimately set aside that order, considering the records holding that nothing of this sort of allegations can be sustained on the face of the record. Is it there? That was set aside. He started the proceeding, DP. We came before this honorable court. This honorable court ultimately suspended the proceeding because in the second suspension, there was a second suspension. The second suspension was on the ground that I have placed certain documents before this honorable court while challenging the orders, which I could not have obtained or placed before this honorable court.
Let us come to the facts of this case. What are the dates, important dates?
My lord, the petitioner joined this institute
Yes.
as the assistant professor in the Department of Psychiatry in 2011.
2011. 20th of November.
No, my lord, his appointment is 18/8/2011. And lordship may kindly come to the list of dates.
Yes.
18/8/2011. This was pursuant to the approval granted by the Secretary to the Government of Assam by letter dated 11/8/2011. He was selected. And then on asking for approval, the approval was sought for. Kindly come to page 26. This is the 8th May.
You are referring to which writ petition?
5114.
5114.
No, why don't we look at the one which was filed later?
Letter one. Yes, I can. Yes, page 31, my lord, here. Page 31. Yeah, it says like this. It has been addressed to the Undersecretary to the Government of India, Ministry of Health Division, Ministry of Health and Family Welfare.
All right. So what is the key issue here, Mr. Mahanta? What is the key issue?
Key issue is whether the petitioner could have been retired by applying 56J or the action is vitiated, not only by illegality, but by malice and wholly without jurisdiction.
Okay. What is the ground on which you are urging this?
Well, first I will submit that the 56J is not applicable in my case.
Okay. 56J of FR, sir.
Yes, FR. Well, Lordship may see it, it is there in the file. You have a next?
83 page number.
Page 83.
Page 83.
Yes. This is this has been quoted in an office memorandum issued by the Government of India, Controller General of Accounts. It is 30th of May 2016. They have issued this, laying down the guidelines. Here they have quoted this. I will just place it from the top, my lord. DOPT video order OM dated so and so has directed all the ministries, departments to conduct periodical review under FR 56J and Rule 48 of CCS pension rules to ascertain whether the government servant should be retained in service or retired from service in the public interest. FR 56J and Rule 48 of CCS pension rules 1970 provide as under. Now 56J. Notwithstanding anything contained in this rule, the appropriate authority shall, if it is of opinion that it is in the public interest so to do, have the absolute right to retire any government servant by giving him notice of not less than 3 months in writing or 3 months pay and allowances in lieu of such notice. One is very important. If he is in Group A, I am in Group A, or Group B service or post in a substantive, quasi-permanent or temporary capacity and had entered government service before attaining the age of 35 years, after he has attained the age of 50 years. This is the requirement. This can be applied in respect of Group A or Group B officers only if he has entered the government service before attaining the age of 35. I entered the government service not before attaining 35. I had entered 42. I entered 42. After he has attained the age of 50 years. Now I have attained the 50 years true. But I entered the service in 42 years, not before 35.
All right.
Therefore, this minimum, what does it mean that the minimum 15 years qualifying service? It has to be there. This is not there. I do not fulfill this. So this is not attracted in my case. Otherwise also. That is what my contention is. Now, going down, my lord, 2 is in respect of other services. 2 says, in any other case, after he has attained the age of 55 years. In any other case, Group C and D, all that. Then, next. Under FR 56, the appropriate authority has been defined as the authority which has the power to make substantive appointments to the post or service. I will take your lordship to the rules also. Who is the appropriate authority? Now it says, has been defined as the authority which has the power to make substantive appointments to the post or service. Now, Rule 48 of CCS pension rules. Retirement on completion of 30 years qualifying service. Lordship may kindly come to 2. The provision under FR provide for retiring a government servant on completion of 50 years of age in the case of Group A and Group B officers, and on completion of 55 years of age in case of Group C officers. Rules 48 of CCS pension rules also provide for retiring a government servant on completion of 30 years of qualifying service. Then Lordship may go to 4. In order to ensure that the powers vested in the appropriate authority are exercised fairly and impartially and not arbitrarily, establishment provision has also prescribed the following procedure. The cases of government servants under FR 56J or FR 56I or under Rule 48(1)(b) of CCS pension rules should be reviewed 6 months before they attain the age of 55 years of complete 30 years service plus 30 years of qualifying service, whichever occurs earlier. Committees shall be constituted in each ministry, department, office to which all such cases shall be referred for recommendation as to whether the officers concerned should be retained in service or retired from service in the public interest. So there has to be a committee. This committee should look into it and recommend. only on that, the appropriate authority will act. Then kindly see criteria to be followed by the committee. Here itself, this guideline says, A, government employees whose integrity is doubtful will be retired. Definitely, integrity if it is in stake. Then government employees who are found to be ineffective will also be retired. The basic consideration in identifying such employees should be the fitness, competence of the employees to continue in the post which she is holding. Next, 6. While the entire service records of an officer should be considered at the time of review, no employee should ordinarily be retired on grounds of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during last 5 years period, his service in the highest post has been found satisfactory. So it says that entire service records should be considered. More particularly in case of promotions, if it is given within 5 years, that should be a ground to consider that his services are satisfactory. Entire service records are required to be considered. Now, my lord, here the lordship will find, skipping over page 89, my lord. Another periodical review guideline office memorandum issued. Now here, they have quoted the FR 56J. You can skip over this portion and kindly come to page 91. Down below, serial 8, composition of review and representation committee. Page 91, madam. 8, serial 8. 8.1. The concerned secretary of the Cadre Controlling Authority, CCA, of the the concerned secretary to the Cadre Controlling Authority, CCA, will constitute review committees of 2 members at appropriate level as under. In case of officers holding Group A post, review committees shall be headed by the secretary of the concerned CCA. Where there are boards, kindly note this also, madam. Where there are boards, namely CBDT, CBEC, Railway Board, Postal Board, Telecom Commission, etc., the review committee shall be headed by the chairman of such board. It must be headed by the chairman of such board. Here, yes, here, well, first thing lordship will consider, it is an autonomous board belonging to the central government, wholly funded by central government. Autonomous body. What is the rules there? What is their constitution? What are the bylaws which prescribes for how these services will be regulated? And the lordship will kindly also bear in mind one thing, that this institution initially was a mental health institute under the state government. It was a hospital. Then, considering the plight, one lady took up the cause. Sheila Barsay. He went up to Supreme Court. Supreme Court directed the central government to take over. In 2006, Supreme Court directed that it should be taken over and it should be maintained by the government, central government. Central government handed it over to the NEC. Then it has been taken over by the Family and Health and Family Welfare Department, and it does the work through the NEC.
Family and Health Welfare Department of Government of India.
Government of India. Government of India. It has been taken apart from the state. The central government institution, but with autonomous status. There is a EC, Executive Council, governing body. which governs, and the chairman of that governing body is the Secretary to the Government of India, Ministry of Health and Family Welfare. He is the chairman. So he is the highest authority here, controlling authority. He is the controlling authority, cadet controlling authority. The issues approval, that too, from the chairman, it must be there. And that is why when initially I was selected, I was appointed with the approval of the chairman. That is the secretary. That is the secretary. Now, for termination, it is specific guidelines say that they will have to take the approval. They will have to take the approval, and the recommendation must be from the committee. The committee, cadet controlling authority shall constitute, and a committee. Now here, if the question is raised, who will constitute the committee? It is the EC, Executive Council. The chairman is the ministry secretary to the Government of India.
Is there any service rules, any rules of this?
Yes,
situation?
I'm referring to, they have some rules. They have some rules. Firstly, I will take your lordship to their recruitment rules. এখানে একটা কপি দিয়ে আসুন। Recruitment rules of 2003. My lord, here, this is recruitment rules 2003, Lokapura Gopinath Bordole Regional Institute of Mental Health. And next page, 21st August 2003, this notification was issued. It was in 99, so no, 2006.
Just let me see the constitution once. 1 minute.
Now,
Just 1 minute, Mr.
Yeah.
Amin. So these rules are framed under Article 309.
yes,
Framed by whom?
framed by the EC. Lordship may kindly come to
No, we'll come to EC. Can it frame the rules under 309?
309. Oh, yes, Lordship has asked me the pertinent question. In exercise of the powers so and so, the Executive Council meeting held on 1/1/2003 and 8/7/2003 respectively, the director so and so hereby notifies the following rules regulating the method of recruitment to the post of teaching and non-teaching staff in the institute, namely. So as per the resolution, so and so Executive Council meeting held on 10/1/23. 2003 and
Mr. Mahanda, that's unfortunately not my question.
Yes.
Can you,
Lordship,
is
whether
there Article 309 rule it
who will
says?
who will make it?
309 only this legislature
My lord,
or as directed by the president.
my lord, we have not till date, we have no such rules, my lord, framed by the government of India. And we have adopted the CCS rules and the appointment
No,
rules.
no, what about these rules? You have a copy of these 2003 rules?
2003 rules is not.
Lokopia Gopinath Bordoloi Regional Institute of Mental Health Recruitment Rules 2003.
Three.
You have a copy of these rules?
It simply says, well, to my understanding, the resolution simply says.
No, we are not even on the resolution. The question is, what
can
rules?
form?
Huh?
Who can make the
No,
rules?
the constitution will have to say who can.
Yes,
Otherwise, it is not 309 rules.
right.
Yes,
309.
as per
Therefore-
constitution, this is not.
Therefore, my submission is, they can only adopt the rules already made under 309.
That will come later. First of all, what are these rules? Under which provision is it framed?
Let them explain, my lord.
That's what I'm asking.
Yes. let
That's
them
what I'm
explain.
asking.
Yes.
Yes.
My lord, the bylaw and rules of the institute is
Have
there.
you understood the question? Just
Yes,
say
my-
that much.
Yes, my lord.
Expecting an answer will be too much, but have you understood the question?
Yes.
These rules mention that these are framed under 309. These are not rules framed under 309. Huh?
Yes.
And you don't have an answer to that. So we'll proceed accordingly. And in the judgment, I'll write that when a question was raised, Mr. Datta could not give an answer.
My lord, the one thing is that the
Come prepared in a matter.
the allegation is that
Hmm.
the
All right, take your seat.
the
I'm
allegation.
asking you whether, how is it a 309 rule? You are going into allegation. Take your seat.
No, my lord, my lord, rules is there, my lord. I can provide it next time.
Today we are closing this matter.
Last occasion, my
Enough.
lord, your lordship directed me to produce the original records of
You
the.
have the records?
Yes, my lord. I have, my lord.
All right. Let him finish. Let Mr. Mahanta finish.
Yeah.
So, Mr. Mahanta, don't enlarge the matter.
But
11:15, I will request you to conclude at 11:15.
Yes.
Otherwise, we'll postpone the hearing to some other day. It's not such a big issue.
My lord, it is not on me,
Hard
my
for-
lord, it is on your lordship.
No, you.
I will point out the relevant things.
You please come.
Yes.
I have understood your case.
Yes.
Your case is that this power exercised under 56J, number one, was done in a very incompetent manner
Yes.
and in violation of the provisions of the rule. And this is nothing but a malafide exercise.
Yes. Out and out.
That's your case.
Yes.
Actually,
Out and
what
out.
more?
My lord, here, as I pointed out, what I see, this lordship has taken this cannot be treated as a rule under 309. But I can only submit that this resolution they have adopted, adopting the rules made by, framed by the central government under Ministry of Health and Family Welfare.
Okay, so these rules are really of no
use. And it doesn't contain the detailed rules, in fact. They refer to what it says, for all medical adoption of rules, it says, adopted from the provisions of CHS rules, mutandis for recruitment in faculty post. This is the result.
Okay, where is the impugned order? Let us see. Where is the impugned order?
Page 82. Dated 5th November 2024.
Page 82.
প্রথমটি এটু আছে না? হ্যাঁ? 79. Well,
Yes.
This is as per your lordship's order. 5th November 2024. In compliance to the provisions of periodic review under FR 56J of the Honorable Guwahati High Court dated 3/10/2024 in WPC 5114 of 2024, the matter has been reviewed. An appropriate authority, appointing authority is of the opinion that it is necessary to retire the government servant in public interest. Now, therefore, in exercise of powers conferred by Clause J of Rule 56 of Fundamental Rules, the competent authority hereby retires Dr. Dhrubajyoti Chetia, Associate Professor Psychiatry, with effect from the afternoon of 17/9/2024 on completing 55 years of age. Dr. Setia has already been paid a sum equivalent to the amount of his pay and allowances for a period of 2 months, calculated at the same rate at which he was supposed to be drawing them immediately before his retirement. This is issued as per Direction of the Ministry, period communication dated 4/11/2024. What is that ministry's communication? It is not here. They will be able to press it. Now, well, this is a very cryptic order. It says, in public interest, you are retired. Nothing more is here. And the first order which was issued is Lordship will find in the same file at page 77, which was challenged in the first read petition, whereupon Lordship directed.
So what is wrong with this order?
Wrong with this order, Malad, that review was carried out. It must contain the reasons. What are the basic reasons which weighed the minds of the authority and why review cannot be allowed? Who reviewed it? The competent authority, the appointing authority passed the order. The earlier order also passed by the competent authority. Is it the competent authority? Again, I am raising this question. Is it the competent authority?
No,
Director.
But the ministry has approved it.
Well, they will be able to show it, whether there is any approval.
So
Because they
therefore,
asked for.
just a minute. We are trying to narrow down the issue.
Yeah,
So
right,
there's no
right.
point making it huge.
Right.
The issue is really small.
Yes.
So otherwise, there was a time when this matter would have been argued for 3 days.
Yes.
We can go on and go on, but we can't
There is
afford it
scope to
anymore.
argue, but then
We can't afford it anymore.
no,
The system
not
cannot-
necessary also. Not
So
necessary.
let us come down to the crux of the matter. The earlier order of review has been subsumed by the earlier order of retirement
Retirement.
has been subsumed by the order dated 5/11/2024.
Right.
This order was passed on a review conducted as per the direction of this court. Now, this order was not passed by the earlier director against whom there are allegations of malafide. He was not there,
Yes, no.
right? So the allegations of malafide are automatically kept out. Now, the second question is, does the ministry, Health Ministry, Government of India, which has got the supervening control through the secretary as the chairman of the board, has approval of this order? The answer is affirmative, at least insofar as the mention is
particular line
concerned.
says.
We'll look up the
Can you
record.
look into the records, Malad?
Yes. So if these two things are satisfied, then what else remains in this?
Then Lordship will have to say whether the order, the review committee considered the entire service record and what are those findings recorded by.
So is it mandatory that entire service record should be?
Yes.
No, it should be considered, but even reasons should be recorded.
No, Malad, it must be reflected that the entire service record from this period to this period has been considered, and we are convinced on the basis of the findings recorded there. At least this must be there.
So if that is there, then there is nothing to interfere with.
Then I doubt Lordship may not go into the details. Roving inquiry will not be made. But the question is, Malad, first thing to be seen, because so many guidelines are laid down on this particular 56J by the Apex Court in very many decisions. I will place one by one all these things I have carried. Wherein it says that it must not appear that this is a process initiated to punish. Here the element of punishment, if it is there, then they cannot.
Hand over the
Malad,
record. Flag mark the relevant page.
Because
Malad-
here Lordship will see 2 departmental proceedings were initiated against me before that on a very flimsy allegations. 2 times I was suspended. All these proceedings are stalled by this honorable court. And then one fine morning, having found that though it is difficult to proceed and punish me on those grounds by pursuing those proceedings, he suddenly resorted to 56J. And 56J, when it doesn't cover me, I didn't join the service of the central government before 35. I didn't join. So 56J, that was not coming. This court has put a ban on this, that you cannot pass any order until and unless you take some order from this court. Kindly see this aspect also. Let me just refer to. Here, Malad, at page 67, I am referring to an order which was ultimately passed by this honorable court. It was, lastly, this order was passed, then I will take your lordship to the other cases. 67, order
Yes.
dated 22/7/2024. Lord, when this 56J was initiated, we came before this honorable court. This honorable court because they asked me to submit the documents. They asked me to submit the documents against me. What are those against me? I said, how can you? Then court said, don't take coercive action against him. But they kept on asking me and eliciting facts from me. They were pressurizing me. So we said that there is a contempt and that or it should be modified. Court said no contempt, but we are passing an order. This IA was filed and that this honorable court passed this order at page 68.
Yes.
Last two para. In any case, before taking a final decision, the respondent either have to take a leave from this court or some orders is required to be passed in the writ petition, in absence of which no final orders can be passed. This was the last order passed by this honorable court.
All right. So, therefore, you would like to argue in the matter on the overall impact.
Yes.
Okay.
Yes.
All right. In that case, we'll hear you. We'll hear you on whatever, because it is possible that this matter may have various subtle aspects. We'll hear you. You can argue the matter the way, but it will take the whole day, obviously. It will be good for the
Not
day.
whole day, at least, my lord, some
First off.
40 minutes, 45 minutes to
All right.
place those records it will require.
All right. All right, then you continue the way you want to argue.
My lord, as I said, I'll be very precise only to indicating the relevant things to your lordship. So, I will take your lordship one by one through my documents I have already submitted. I may not refer to everything, but just page 31, that is the letter I placed it first. My selection was indicated and asked for approval. Page 32, relevant portion, my lord. Page 32, relevant portion of Annex 1, letter dated 8 May 2011. As per provision 24 of the bylaws of the institute, all appointments of employees of this institute shall be made by the director in accordance with the procedure of the bylaws of the institute. Since the director himself is the chairman of the selection committee, it will be prudent to obtain the approval of the chairman of the executive council of this institute. The secretary MOH and FW is ex officio chairman of the executive council for LGB RIMH. I am therefore directed to request you to kindly place the matter before the chairman for his approval. And approval was granted by the next page 33. Next page, it was the letter from the Undersecretary to the Government of India. I am directed to refer to your official letter such on the subject mentioned above and to convey the approval of the Secretary, Department of Health and Family Welfare in his capacity as Chairman, Executive Council, LGB, Regional Institute of Mental Health, to the recommendation of the Selection Committee for the post of Assistant Professor Psychiatry in the Institute. Then I was appointed. Next appointment letter, page 34. Your Lordship will see page 36. It says all other service conditions. Paragraph 12, my lord, page 36. This is my appointment letter. They have said that what it says, with reference to your interview for his post of assistant professor of psychiatric, you are hereby offered the appointment to the post on the following terms and conditions. They have said, I will be in probation, all that is there. We can skip over that part. Lordship may come to serial 12. This is relevant 36. Is 36. All other service conditions which are not specifically mentioned herewith will be governed by the central government rules as adopted by this institute. Mutatis mutandis for the employees of this institute. This is the terms and conditions. So in my case, Lordship has seen, rules are only the rules framed by the central government. They do not have a rule.
Yes.
Then I was promoted. I was promoted in 2017 with effect from, that is 23/5/2017, page 37, associate professor. Since then, I'm working as assistant associate professor. Then, first suspension comes. Page 38. Page 38. This was the first suspension order contemplating DP against me. It says disciplinary proceeding against so and so is contemplated. Now, therefore, director exercising the power conferred upon him, Juris is suspended. I challenge this. This was suspended first. Next page, Lordship will find. It was suspended, then this was set aside. Page 40, Lordship will find the effective part, 24/3/2023. Here, reasoning has been given. Lordship may kindly come to page 41.
Yes.
Paragraph 6. This court, having perused the order dated 21/12/2022 and taking into account the detailed observations so made by the coordinate bench and any deviation to the said observations should amount to sitting on appeal over the said order, which this court cannot do. This court, on the basis of the reasons assigned in this said order, set aside the suspension order dated 12/10/2022 impugned in the instant proceedings. Taking into account that the impugned suspension order have been interfered with by this honorable court for the reasons stated herein above, this court, however, would make it clear that the observations in the order dated successors has to be taken only as observations to the challenge to the suspension order dated successors. Therefore, the said observation made in order dated so and so under no circumstances shall affect the rights of the respondents number 1, 2, shall have a hearing in bearing or shall have a bearing in respect of the department proceeding if so initiated against petitioner. So this was done. This sought leave to prosecute me criminally. Court said, paragraph 8. There is also a prayer in the interrogatory application seeking a direction to the investigating authority to investigate the matter, taking into account that the provisions of Code of Criminal Procedure so and so provides adequate remedies. This court is not inclined to pass any direction for making investigation. However, liberty is given to respondents to take appropriate steps as deemed fit in terms of the provisions of the Code of Criminal Procedure. So they file a FIR. Allegations were there. That next page, my lord, 43. This was the final report submitted by police after inquiry. It says that Lordship may kindly read it because facts are important. Facts disclosed during investigation. At the time of investigation, the complainant witness were examined. After examination of the witnesses of the case, no proof was found that the accused persons of the case have committed offense of the case On the other hand, at the time of investigation of the case, accused Dr. Dhubajyoti Chetia and Dr. Kamal Narayan Kolita obtained pre-arrest bail from this honorable court and appeared before the police station, and after investigation released after investigation released Amanuddin Ullah also from the police station, serving notice under section 41A CRPC. On spot investigation of the case, no sufficient evidence have been found against the accused Dr. Dhubajyoti Setia, son of so-and-so, resident of so-and-so, and Kamal Narayan Kolita, son of so-and-so, resident of so-and-so, district Kamrup, Assam, so-and-so, district so-and-so, Assam, regarding commitment of offense of the case and obtaining verbal permission from the higher authority of the police, and due to lack of sufficient evidence for the commitment of offense under section 406 of the Indian Penal Code, submitted final report before the honorable court. So final report was submitted and it was closed. They lost some allegation that they came to know that some persons, for their personal gain, shared through email some secret information of LGBRIMH, and through departmental inquiry came to know that Dr. Dhubajyoti Setia and Kamal Nayan Kolita committed act through one unknown person, Amanuddin Ahmed. As per itself in this. Then, well, what happened is Amanullah, he sent a representation to His Excellency the Governor, raising certain complaint against the institution. He sent a copy of the same in my email. They took it that it is me who has passed on this information to me. He wrote representations. He got it, my mail probably while surfing. Sent a copy to me also, and one is Kamal Nayan College. They thought that it is me who has passed on this information, so that's how they have lost the complaint against him. On that ground, they wanted to prosecute me. And I was suspended for the leakage of internal documents. This honorable court looked into the entire file in that suspension order when we challenged, and recorded the finding, the judgment to Asil order 2, that it does not constitute or cannot be constituted to have done this. He has passed on these information. There is nothing. One cannot think of that he has done it. There is nothing on record. One can write it. One can get it. They are sending an email to the doctor, after 3 months of his representation. Anyway, cannot affect.
What is the information he had sent to your client?
He has sent that copy of the complaint, which was filed before the governor.
By that person?
By that person, Amanullah, Amanullah. I do not have any.
Amanuddin Ahmed.
Amanuddin Ahmed. Yes, Amanuddin Ahmed. He submitted it. And
he submitted a complaint before
to the
Assam governor.
To the governor of Assam.
All right.
And SCC copy was forwarded to me. That they knew from my mail. So they took it that it's me who has given that information to him regarding the internal functioning of this. The complaints were.
And the complaint was regarding internal functioning of the.
Some complaints were there, my lord. There, he has made some complaint about the functioning of the authorities, internal functioning of the authorities.
All right. Yes.
Therefore, they initiated the proceeding against me and that Kamal Nayak also, and that lost that FIR also.
But FIR ended in final report.
Yes, ended in final report. It was done. My lord, that copy forwarded to your lordship.
Yes.
The order of this honorable court of the collateral bans passed
21/12/2022.
on 21/12/2022. Here lordship will see. They asked me to give this Uh, mm. Lordship may see from paragraph 2. What does it say?
Yes.
Petitioner Dr. Dhrubajyoti Setia is an assistant professor in the Department of Psychiatry Department in the Lokapura Gopinath Bordle Institution Resolution. The petitioner was issued a so-called notice dated 23/9/2022 by the OSD in charge Deputy Director of LGBRI, wherein in the first paragraph it is stated that with reference to file number so and so, the petitioner, who was also in charge of the library, had failed to submit the list of books recommended by the faculty members, and the delay in doing so was not justified in a satisfactory manner. So, list of books regarding. The OSD in charge Deputy Director in second paragraph provides that the authorities have sufficient reasons to believe that the petitioner had been deliberately and repeatedly refraining from complying with the official instructions of the competent body. Third paragraph provides that the conduct of the petitioner is not providing the list of books recommended by the faculty members has caused severe inconvenience in public service and wastage of precious time of the government. The fourth paragraph provides that the act of not providing the list is unbecoming of a government servant and is considered to be a serious misconduct as per CCS conduct rules. Accordingly, the petitioner was asked to show cause as to why penal provision will not be imposed on him. The petitioner gave his reply by his undated reply, which is at page 31, so and so. In the meantime, the OSD charged Deputy Director further notice to the petitioner dated so and so, the relevant portion of which is extracted here. It has come to the authority that a few information pertaining to the institution have been sent unauthorizedly to the outside agencies. This is a matter of serious concern. The institute has already initiated internal inquiry. In this regard, you are therefore requested to furnish the following information to the undersigned by today. Do you know the persons named Mr. Bhogatlal Dutta and Amanuddin Ahmed, bearing email ID so and so, so and so? Are you aware of any activity of sharing information of the institute through any of these persons mentioned above? This was also given to me. This is the petitioner gave his reply. Also dated such and such. It is extracted as, with reference to your letter reference above, I would like to submit the following. The persons referred to in the letter, Mr. Bhogatlal Dutta and Mr. Amanuddin Ahmed, bearing email IDs as stated, are not known to me. I am not aware of any activity of sharing information of the institute to any of the persons mentioned above. In the aforesaid circumstances, the petitioner had been placed under suspension as per order dated 12/10/2022. The order of suspension is also extracted as below. We can skip over. Then 6. The order of suspension is assailed in this petition by referring to the communication that is so and so, that the allegations against the petitioner is that he had failed to provide the list of books recommended by the faculty members within time, and it was considered to be a serious misconduct. And according to the petitioner, he said view formed that by not providing the list of recommended books within a period of time, as expected by the respondents, would be a serious misconduct, is highly disappropriate and irrational. Mr. Dr. So-and-so, respondents have brought to notice of the court that there are some other issues with regard to the petitioner as to why he was placed under suspension. Accordingly, representation made by Amanuddin Ahmed, a resident of Dibrugarh, made to His Excellency the Governor of Assam dated 22/11/19, is placed on record. The document placed on record before the court is actually a forwarded message from Amanuddin Ahmed, also to the petitioner Dr. Dhrubajyoti Setia, in his email address so and so. Accordingly, the respondents seek to take a stand that the communication dated 6/10/2022 was issued to the petitioner in the background, that the representation raising some serious complaints against the institute by Amanuddin Ahmed made to His Excellency the Governor Assam. A copy thereof had also been forwarded in the email address of the petitioner, and therefore the respondents are of the view that the petitioner is providing inside information to the institute to the said complainant Amanuddin Ahmed, which according to the respondent is also a factor that was in their mind when the order of suspension was passed. In the circumstances, by our earlier order dated 2012-2022, we required the respondents in the LGBRIMH to produce any relevant materials that they may have in their records, which may indicate that the petitioner is giving some inside information to the institute to the complainant Amanuddin Ahmed. Consequently, certain documents are produced before the court today. The first document is the complaint dated 22/11/19 from Amanuddin Ahmed sent to the email address of His Excellency the Governor of Assam. The second document is the forwarded copy of the said complaint to the email address of the petitioner Dr. Dhruvajuti Setia. The third document is dated 23/11/19 with the expression instate PDF and some other similar inscriptions which does not carry any discernible meaning. The fourth document produced is again the representation of Amanuddin Ahmed made to His Excellency the Governor of Assam, forwarded to the email address to the petitioner. But on top, one expression, Kamal Kolita, is written. The fifth document produced is some information obtained from the email address of the petitioner, which again does not reveal any such information that it is the petitioner who is providing any inside information to the respondents. The sixth document is an application under the Right to Information Act by the complainant Amanuddin Ahmed made to the Public Information Officer of the LGBRIMH seeking certain information pertaining to the internal affairs of the institute. None of the documents produced before the court as indicated above leads to any such conclusion that the petitioner had provided any inside information regarding the institute to the complainants Amanuddin Ahmed. In fact, on the other hand, it appears that the complainant Amanuddin Ahmed had made some application under RTI seeking such information to the institute. Further, the complaint made by Amanuddin Ahmed to His Excellency the Governor of Assam is dated 22/11/2019, which is almost 3 years back, meaning thereby that the inside information might have been given by the petitioner even prior to it. For the reasons stated above, that we are unable to accept any serious allegation of misconduct against the petitioner other than that he had not submitted the list of the recommended books made by the faculty members within the time expected by the authorities. Prima facie, it appears that the same cannot be a reason to place an assistant professor of the institute under suspension. If the authorities feel that by not submitting the list of recommended books within time itself, it also a misconduct, they may proceed in a departmental proceeding against the petitioner. But considering the nature of the allegations, we are of the view that the same may not justify the petitioner to be kept under suspension, nor is there the possibility of the petitioner of either influencing any witness or tampering any documents in much as only allegation is that the list of books are not submitted within the time preferred by the respondents, and the petitioner had given its own explanation for the purpose. Accordingly, the impugn order of suspension data shall remain stayed until further orders. So this order, on the basis of this order, the subsequent bench set aside the suspension order and granted them liberty to go for criminal prosecution if they so.
So by this order, the first suspension order of 12/10/2022
was stayed first,
stayed.
Then it was set aside by the court on that page 40, Lordship has seen that 24/3/2023.
Yes.
Referring to this order at paragraph 6, the detailed order was recorded. So considering the same, this was set aside.
Then there was a second suspension.
Then there was a second suspension. So criminal case has come to the final report, my lord. Lordship has seen page 43. Final report was submitted so far that passing of internal information to that complainant, Amanuddin, that was no proof was found. They have investigated and finally submitted the final report. FIR is at page 46, that whereupon the FR was filed. Same thing, I am not taking your lordship to the contents of the FIR dated 21/11/2022, page 46. This FIR was investigated into and final report at page 43 was submitted by the police. Now, then comes the second suspension. Page 48, my lord, annexure 9. Here, lordship will find as many as 13 grounds were mentioned. Second, here lordship will see, if I take your lordship to the all the grounds, lordship will definitely find that these are grounds which are very flimsy. One by one, I will take it. At least lordship will see this. So-and-so Setia had been made aware that a disciplinary proceeding was contemplated against him for a few misconduct, namely willful insubordination, unauthorized communication of official information, video order number so-and-so, that is so-and-so. That was the first suspension of Ramallu. In the meantime, after receipt of the CAG audit report for the financial year 21-22, the preliminary inquiry conducted video communication referred above, as instructed by the audit, it has been noticed by the authority that 115 numbers of books costing around rupees 2,46,538.23 are missing from the library, and 81 numbers of journals costing around 3,31,076 were not supplied by the concerned vendor during their respective contract periods and during the tenure of Dr. Dhruva Setia as in charge library. The matter of the loss of library resources has been in the knowledge of Dr. Dhruva Setia since 2019, but the matter has never been brought to the notice of the authorities. The reasons for the loss of these public assets could have been ascertained and recovered through proper investigation if informed on time. The performance bank guarantees of the vendors were released without any deduction for professor certifying falsely by Dr. Dhruva Setia regarding their supply status. Files were sent by Dr. Dhruva Setia to the account section for the release of advance payment to the suppliers without assigning or obtaining the signature of the authorities and the witnesses on behalf of the institute in the agreements, violating the clauses of relevant supply orders. Replies received from Dr. Dhruva Setia during the preliminary investigation were also found to be misleading and unsatisfactory. In view of the above, the authorities is in the process of initiating the disciplinary proceedings against Dr. Dhruva Setia, and the charge sheet for the same will be sent to him in due course as per rule. It is also to be mentioned that Dr. Dhruva Setia has been relieved from the duty as in charge library since 12/10/2022. However, it has come to the notice of the authority recently that Dr. Dhruva Setia is obtaining information from the library pertaining to the issues under inquiry, communicated via letter as referred above from the subordinate library staff through WhatsApp messages on 10/4/2023 with Mrs. Sangeeta Gogoi, library assistant, 4/10/2023 and 5/10/2023 with Mrs. Tanu Deuri, library assistant on such all these dates, and such with Mrs. Jyoti Prabhat Gautam, library assistant. Dr. Dhrubajyoti Setia could have submitted a request to the authorities to obtain the information for the preparation of his reply without obtaining it in an unauthorized way. Therefore, in this case, there is a strong possibility of witness tampering or influencing, as all these staff worked under him for a long period of time. Hence, to initiate an unbiased, uninfluenced, and impartial disciplinary inquiry, Dr. Dhrubajyoti Setia has been placed under suspension with immediate effect, invoking the power vested under the director by Rule 10 of the CCS rules, so Clause 12, constitute bylaws of the institute. It is therefore ordered that during period he will be headquarter will be there. We can skip. This is the suspension, second suspension. This was challenged. And it was stayed by order dated 29/1/2024, 51. Page 51, Lordship will find. Last 52, last para. Till the next returnable date, impugn order dated 21/11/22 shall remain suspended, but it is made clear that the petitioner will refrain from interfering in any form, in the manner, in respect of any disciplinary proceedings. This was extended, and this is Malad.
So was there any departmental proceeding
Yes.
initiated?
Then again, kindly
No,
come
no,
to
no,
page
no, no,
54.
no.
On this,
This order does not initiate departmental proceeding.
here contemplated this. This order of suspension.
The learned single judge state the departmental proceeding. Is it
Here,
correct? Disciplinary proceeding.
no, disciplinary proceeding was contemplated, it says here. This suspension order was stayed.
All right, you may not answer, but the
No, no,
disciplinary proceeding which was stayed was not
Subject to
initiated.
suspension, so and so, suspended. But it is made clear that he will refrain from interfering in any form, any manner, respect of any disciplinary proceeding that is being initiated. That is being initiated. They say that it is contemplated, therefore, I was said that you don't influence anybody there. If the, and then they initiated the DP. I approached this court. So WPC 2092 of 24, page 53, annexer 11, annexer 11. This was state. Last para 55, my lord. In the interim, the further proceedings of the disciplinary proceeding against the petitioner shall remain suspended till the next returnable date. It was suspended.
So there are two consecutive orders suspending the disciplinary proceeding. But the fact remains that there was no disciplinary proceeding initiated.
Disciplinary proceeding was thereafter initiate করেছিলে? Disciplinary proceeding?
Two disciplinary proceeding is going on, my
Two
lord.
proceedings were initiated.
Two proceeding is going on, my lord.
Two proceeding
So
was initiated.
which were the proceedings stayed by the High Court by these two orders?
My lord, earlier for
What was the disciplinary proceeding stayed by the High Court by order dated 29/1/2024?
That
31/7.
into other.
The irregularities of in the library, my lord.
Where is that notice by which disciplinary proceeding was initiated?
So-called notice is there, my lord.
Where is it?
So-called notice was there.
Where is it a part of the record?
আমার হাতে কিছু না? 22/1/2024 এটা আমি annex করেছিলাম নাই করা My lord, the first proceeding was initiated on 22/1/2024.
Is it a part of the record?
It is not a part of this record. It is not a part of this record. This was challenged in another WPC. No, no? Kuntu? WPC 2092 of 2024. This was challenged. this proceeding, and this was stayed. This was,
What is the case number, Mr. Mahanta, you said?
my lord, this is case number,
2024, annexure 11.
this is annexure is given here. 53, page 53. That is the first first GP was stayed. First GP memorandum was 22nd January 2024.
What has happened to the writ petition, WPC 2092?
These are pending, my lord.
These are pending, then this will have to be heard together.
These are pending.
And what happened to WPC 402 of 2024?
WPC.
Yeah.
1402, Lordship.
No, 402.
No?
402 of 2024.
This is also pending.
Then these matters will have to be heard together then, because you are referring to these proceedings.
Yes,
The-
those
the
proceedings
court
are
has
pending
to-
here. Not denied, these are pending and they were
No,
stayed. Now,
These writ petitions, are they not required to be heard together with these two writ petitions?
it will be prudent if it can be heard together.
That's what, because you are referring to those
Yes,
materials and then.
because here, my ground was that 56J is a shortcut method adopted because as they could not proceed through and complete, initially they wanted to punish me by proceeding departmentally. That is what I want to project.
That's all right. All I'm asking you, but if there are two other parallel proceedings pending, which has got a bearing in this proceeding, because you are referring to the
True.
malafide.
True.
So the court cannot make any observation.
As I said, when Lordship will consider these aspects also, those petitions can be considered and decided in one go.
Correct.
Because what will be the bearing of this? I will be arguing on that. I am now referring to only the stay orders and the fact that those petitions are pending. They could not have initiated 56.
Correct. So what is your suggestion? These matters have to be heard together along with these two.
Then, my lord, all these records should be here.
Correct.
Along with.
Because this was not pointed out earlier.
This was pointed out, but not in that form that the all proceedings are pending. Stay was granted. And even 56J, that was also challenged. That proceeding is also pending.
Oh.
Their stay order was passed as I have placed.
Oh,
That
that is WPC number?
511, huh?
5114.
51, this is 1402. 1402 of 2024. Right?
So that means there are three other writ petitions.
Yes.
Which are pending.
Yes. 56J, when they initiated, we came before this court. Court said that you don't, because initially I was asked to give all the.
No, that's right.
Against.
That's right. The only question I am asking is, all these writ petitions will have to be heard together.
Lord, it will be better because all things will go together and it will be.
No, better means otherwise we'll not look into these issues.
Lord,
there is no option. It has to be heard together.
Lord, question is whether during the pendency of all these proceedings, having initiated these departmental proceedings, is there any justification suddenly to jump upon 56J and take the call?
That's right. That's a question. But even to appreciate that question, all matters will have to be there.
Yes.
Ultimately,
if I come back,
GR case is
all
not,
these proceedings.
GR case is still pending. And by order dated 318, my lord, in my GR case, the honorable magistrate directed to reinvestigate the case.
No, that
Not
there cannot be
GR
any direction to
case.
reinvestigate.
And
Reinvestigate, no direction can be issued. If they have not challenged the order, it is their problem.
my lord,
Magistrate
the
can only
issues-
direct further investigation, not
the
reinvestigation.
issues of before the
Let me see
DP,
the record. What is the approval of the?
DP are not considered by the review committee. Considered by the review committee.
No, not this, the departmental record.
Yes, my lord.
Where is the approval of the ministry of his 56J order? Mr. Datta, don't give this mountain of record. We don't have time to go through
My
it.
lord, here
Flag mark. what do you
was
want to-
annex a whole entire service records is there, my lord. And DP is going on under the provisions of CCS conduct rules, my lord. And the issue is not remotely connected with the issue of DPs, my lord. I have stated here. And ground on which they have projected this case before this honorable court, I have answered in my para number 30, my lord. All grounds they projected, allegation brought against you. And the issues before the DPs not considered by the EVM authority. India report is stated that. And the report he submitted found to be discrepancies, and he admitted.
So the original order retiring him compulsorily under 56J
Yeah.
was dated 17/9/2024.
Yes.
Then this communication issued by the Under Secretary
Yes.
says that order is illegal.
Yeah, illegal, though, my lord, uh, since 1999-2024, my lord, we have not, the institute has not received any communication from the government that on 1999-2024.
I'm disposing it upon this basis because the government ministry has said it is illegal order.
My lord, thereafter, my lord,
Have a look at the order.
officiating director passed the order.
Record
Officiating director passed the order after the in compliance of this honorable court's order, reviewed the matter and the ministry directed.
Where is the approval of the ministry regarding that order?
My lord, last page, my lord. Last page, my lord.
So, Mr. Mahanta, then you please file a additional affidavit, bring this on record.
Yeah,
Those
let
are
him-
cryptic things you are not disclosing. The ministry says the order was illegal.
My lord, though he was, the institute has not received any information, communication from the government that you remove and you take over the charge of the office of the directors. But on 19 and a half and 1 month later, the government issued the order. We have received at 19.
Mr. Datta, please answer the queries of the court. Pursuant to the order of this court, the review order of 5/11/2024 was passed.
Yes.
Where is the approval of that order from the Ministry of Health?
My lord, last page, my lord.
Last page, which page? Where is that?
Yes.
That says the earlier order is
That
illegal.
says that is illegal. He doesn't have the
Where's
authority.
the approval?
It is illegal, but officiating director, present director is directed to take appropriate action.
We'll reserve the matter for order.
The family is not in law, therefore, the authority of the Ministry of the Family Welfare Government reviewed the order dated such and such as per the observation of the Honorable Court by the order dated such and such. In view of the above, the order dated 17 become an order passed without the authority. Institute is directed to take necessary corrective action in compliance of corrective action in compliance of the court's order and rule and regulation by 5th November 2024 under intimation to the ministry.
So the corrective action.
Corrective action.
To confirm his.
Review the,
we
we cannot, my lord.
Suo motu contempt notice to your director. Mr. Mahanta,
Yes.
can you please file this by an affidavit tomorrow? We'll have
Yes.
it day after tomorrow.
Yes,
Now we are going to issue suo motu contempt notice.
yes.
You are playing hide and seek with the court. The ministry has clearly said that the order of retirement was illegal. Take corrective action. And the corrective action you take is confirm that earlier order.
My lord, reviewed by the ministry.
All right, please file it day after tomorrow. We are
Let-
issuing a
let-
suo motu after this comes. We may
Yes.
consider issuing a suo motu contempt notice.
Virtual record
Who is the director now? Huh?
copy should be given to me.
Yes. Give the copies. You furnish it. What is your instruction, Mr. Gogoi?
Lordship, in respect to the other cases, we have no specific rules, Lordship. As because Lordship has directed us to in earlier cases, whether that order was valid or not. As per that, I have obtained instructions, Lordship. Otherwise, they have the power, Lordship. As per the EC, they have to take approval, Lordship.
No.
Lordship.
The communication regarding justification of retirement, compulsory
Lordship.
retirement of the petitioner
Lordship.
was sent by the OSD,
Lordship.
Joint Director, to the
Lordship.
Private Secretary of the Secretary of Government of India, who is
Lordship.
the Chairman of the Executive
Lordship,
Council,
Lordship.
giving him the justification.
Lordship.
That reply came that the earlier order is illegal.
Lordship.
Carry out corrective measure
Lordship.
as per court's order.
Lordship.
And the corrective measure is confirm the earlier order. What kind of justification is this? This is playing fun, hide and seek with the court.
No, my lord, it is based on the review committee report, my lord.
Okay. Now we know what is happening now. You have got the,
Review committee report is there, my lord, originally it's there, my.
all right. Has the review committee report been approved by the committee, by the secretary, the chairman?
Not necessary, my lord. There is no provision to approve.
Then why have you sent it the earlier round?
Yes, my lord, every time we have sent the ministry, my lord, but not necessary to take approval from the ministry.
And you are also not taking any stand in the matter? What is the?
In respect of that, Lordship, it is autonomous institute, Lordship.
uh,
Regarding appointment disciplinary proceeding, they have, Lordship. It is up to the chairman to the executive council. And chairman is represented by the Lordship, the LGBI Institute, Lordship. Chairman, which is the secretary of the Ministry of Health and Family Welfare, it is represented by the LGBI, Lordship.
Now, how can it be?
Lordship,
How can it be?
Lordship.
The Union of India.
Union of
Ministry
India, Lordship, we the respondent number one, the Union of India represent the Ministry of Health and Family Welfare.
Ah.
Like the chairman of the executive council is the Lordship. Secretary of the Health Department, he is a autonomous body chairman, Lordship. Not as a Lordship, Ministry of Health Department Secretary.
Maybe, but he's the same person.
Lord, he is the same
Then
person.
you don't have any instruction in this matter.
Lordship, regarding that part, I have no instruction. Otherwise, Lordship, he is representing that chairman, Lordship.
Oh, you all are
Yeah, yeah.
turning these court proceedings into a mockery.
Lordship.
Really? For both. He's acting for both the director as well as the chairman, although he is a person holding the highest authority and he's a central government employee.
So we'll record and delete your name from the array of parties. Then what are you supposed to do here?
Lordship, up to chairman, we have no rules, Lordship. Up to chairman.
Above whom? Above chairman, who's there? in the ministry?
Lordship, Ministry
Prime
of
Minister.
Health, no, Lordship, Ministry of Health and Family Welfare, it's represented by the Secretary, Lordship. We are representing him, Lordship.
What is his stand in the matter?
His stand is that, Lordship, that particular order which was passed earlier, Lordship, it was not a valid order, Lordship. That is before the Lordship, I have already placed it, Lordship. I have already placed it in earlier order and that was also disapplied. It is not a valid order, Lordship.
File a short affidavit.
Lordship.
Yes. Yes.
We'll have it on Tuesday then. Tuesday. Again on
Tuesday.
Tuesday. Coming Tuesday.
No, आज की बात. It will be.
I think the superintendent already subject 2.16 regarding the age of.
And this the pending writ petition regarding is no way connected with this case, Lordship. As because that particular interim order also,
Yes.
Lordship, in respect, not in
It is
respect,
not correct. That is what I was hinting
Lord-
at Mr. Monto in the
Lord-
beginning.
Lordship.
He is the one who is inviting this problem for his client.
No, Malak, what I.
He is the one who is ensuring that the hearing goes on till September 2025. Because he speaks very well
No,
and he wouldn't let go of an opportunity.
no,
to
no, Malak. We hardly
unfold
get
this
such
case.
opportunities, no
But
doubt.
he is dragging
But-
his client into October
But
2025. He
I
not
wanted to throw that the clear picture before this honorable court because he might come down and say, well,
by all means, Mr. Monto, but the picture will be clearer in October 2025. You have to be ready for that also. Everything has a consequence.
definitely.
If you would not have enlarged it so much,
Yes.
we would have finished it with this
Well,
proceedings today.
But
itself.
because Lordship has also not seen that record. I am not privy to this. I could not know. That is why initial record inspection was required.
All right, so now what is to be done?
Now, my lord, because without going into all other issues, Lordship will go on that because the factual background is there. All these cases are pending. He himself was retired on that day. He has no authority to do it. And that is.
So initially the idea was just to see whether this process of review carried out after the court order was in
Yes,
accordance with
yes.
law or not.
Yes.
So you expanded the whole thing. I told you in the morning, conclude in 15 minutes, giving you an hint that if you enlarge it, you will get into trouble.
My lord,
But you have
because
decided to enlarge it.
I have the duty cast on me to place everything so that there will be a fair
No, no,
decision.
that's all right.
That's why.
That is your decision.
Yes.
You have a right to take a
Yes.
stand on that. All I'm saying is now that you have decided to enlarge it, the process is going to take time.
No, because it's not
because then
necessary.
the hearing, other matters are not part heard or heard by this court.
No, no.
Then
Now,
it will
now,
take time.
now because on the face of these records produced, it did not have to go to all these aspects. My submission regarding the pendency of these cases, stay orders passed by this court, they have taken a course which ought not to have been done. And that to a person, retired person.
Senior counsel listed by so and so.
Earlier order which
We'll
was-
fix it on Tuesday, nothing else. Yes. Also heard Mr. K. Gogoi, Learned CGC appearing for the respondent number 1. Mr. A.K. Datta, Learned Counsel, representing the respondent numbers 2,
Thursday by
2, 3, 4.
2, 3, 4.
2, 3, and 4.
2, 3, and 4. And Ms. R.
Kakoti.
Kakoti, Learned Counsel, appearing for the private respondent. On the request of Mr. Nihalta, these matters are directed to be listed again on.
Lordship, 27 Lordship, 25 I have.
You have difficulties. No, let us first see
Let
what.
me on Thursday, otherwise, day after tomorrow. I'll file it by tomorrow. Lordship will record that.
But day after tomorrow before some other court. It's
I
not
see.
confident for the. convenient.
25th to
Then let it be released from part heard, go to some other.
No, my lord, Lordship has taken so much of trouble and time has been.
22. As fixed. part heard
25th.
matter. So as to enable the writ petitioner to file a short affidavit in the light of disclosure made today by the learned counsel for the respondent numbers 2, 3, and 4 by proceeding the records, by producing the records as called for by the court.
A copy of the.
Modis.
I don't check on it around here.
No, I get it. Same.
Have you?
Same. I have
Give him
only,
the copy.
I only supplied those. I have not supplied those.
But Mr. Datta, this is a place you will have to really come up with good answers. You are playing a hide and seek. When it mattered, you send it to the secretary, the chairman. Now that the opinion has come, which doesn't favor you, this time you have decided not to send it. Be aware what order is coming on 22nd.
Sit on 25th is 25th out of.
Well, not necessarily, because what we see on that day, he is otherwise also here, he has no bearing at all.
1st April. 1st April.
Deeply obliged.
Hey, only I'll just 2 minutes break. Mr. Mahanta, if the affidavit can be circulated in advance,
Yes.
short affidavit,
Yes.
what are the disclosures here?
This week itself.
Yes.
Obliged.
Because now that it has been hard, I don't want to defer it.
Yes.
Item 3.
Lordship, I beg to apologize before your Lordship as well as the senior counsel. Lordship, can this matter be taken up after some time? There's a partheid matter going on. The main counsel is arguing this case. He's engaged in that court, Lordship.
We'll see. Let him start. What is the matter? Is it fixed for disposal today?
Yes, my lord. My lord, in this case, the petitioner, my lord, I have given the list of deaths, my lord. Probably it is there, my lord.
Yes.
He was appointed as a junior assistant. Originally, she was appointed in a district office. After filing of the case before this honorable court, she was placed in a directorate. Thereafter, she was denied promotion. And in that case also, she filed an petition before this honorable court, and on the direction of this honorable court, a representation was filed before the authority, and it was rejected arbitrarily. Against that, I have filed this petition.
Promotion to which post?
A senior assistant, my lord.
All right. The promotions are to be given as per which rules?
My lord, 1973 rules, my lord.
1970. You can disclose the whole rule, name of the rule, entire rule.
Assam Directorate Establishment Ministerial Service Rules 1973.
List of books has been given.
My lord. Page number 168.
Yes.
My lord, relevant rule is at 9, page 174.
Yes.
Rule 9, page 174.
Yes.
Appointment shall be made by the appointing authority by promotion on the basis of seniority come merit from amongst the junior assistants of the service who have rendered not less than 4 years of service. That is the criteria, my lord. Oh, sorry, on first day of April.
So, is there a seniority come merit?
Yes.
So, where is the seniority list?
My lord, seniority, provisional seniority list was prepared. Annexure 11, page 39.
Yes.
page 39, annex 11,
Name of petitioner is in serial number 45.
45. So on that ground, I have been rejected in the recent order, my lord. That provisional declaration list was not finalized till 2020. And
So are you the senior most?
yes, my lord.
You are the senior most.
Yes, my lord.
But then this list
It
is
was
of-
wrongly prepared. I have filed an objection against the provisional list. It was not decided. Thereafter, I have filed this writ petition before this honorable court on the direction of this honorable court. They have considered my case and it was rejected by order dated 29/12/2016.
Where is it?
Annex
Page-
15, page 47. May I read, my lord?
you just sit for a minute.
Yes.
Your client is already retired from service.
Yes, my lord.
Then what do you want now?
My lord, on national benefit, my lord.
No, that's not possible.
My lord, in that order at page 48, In the first paragraph, last line. First paragraph, last line, 48. Accordingly, this directorate has kept one post of UDA vacant in the office of the Director of Health Service, Assam. But in the third column, last line, but at the present, there is no available vacant post. So it is quite contradictory, my lord. That is one point. And secondly, I was rejected because I was placed at serial number 45. But that was provisional list. It was not made final. In the affidavit, they have submitted that that provisional list was not considered. But here it has been seen that that provisional list was considered. Your Honor,
So, Mr. Goswami, after nearly 8 years of retirement of your client,
my lord,
you now want the court to issue a direction to promote her to the higher post and give her all
No, my lord,
consequential benefits.
I had-
Show me, can you show me an
no, my
authority?
lord, I had approached before this honorable court earlier in the 2017, 2000. While I was in service, my lord, I had approached, and during that service period, direction was given to the director, and it was rejected arbitrarily.
Correct. So today, first of all, whether it is arbitrary or not, that we'll examine. But today, what is the direction that can be given? How can they consider you for promotion?
No, no promotion, my lord, notional benefit, because I have already retired.
Show me a
My final-
authority. Show me a
Because
authority.
your lordship's order is there, my lord.
Show me a authority. Is there a right to be promoted?
Promotion is not to be given effect, but notional benefit, because your lordship has passed an order.
Notional benefit of what? You have got your assured career, got
Financial-
the career progression benefits you got.
Yes, ma'am.
Then
Only your lordship
in,
has,
in lieu of promotion, they have given you the financial benefits.
yes, my lord.
Then what remains now?
No, no, your lordship has passed an order.
That is the notional benefit.
Yes, my lord. My lord.
Because your client could not be promoted,
Yes.
in 2014, they gave you the MSCP benefit.
Yes, ma'am.
Second benefit, the director says is not possible because you have not completed the requisite
No,
length of service.
year of service has been completed because I was placed at serial number 45.
You retired already. These are all.
But my submission is that it has already been covered by your lordship's order, my.
No, that was a case where, though the petitioner was within the zone, his case was not considered on the ground that his service was not regularized.
Regularized.
But the court says that the service was not regularized is not his fault. He should have been considered when his juniors were considered.
In this case also, my junior was.
They have done it, but they said that no vacancy is there, so they gave you the MSCP. So first you return that MSCP benefit. Return that money. You can't have both.
Yes, my lord.
So file an
I will-
affidavit.
I will take
So
instruction.
this is the amount and you are willing to
Yes.
return it.
Yes, ma'am.
Then we'll consider, but the direction will be only to consider your case. So you are understanding the consequences. I think these are completely frivolous litigations. Think about it, Mr.
Yes.
Goswami. If you press it, we will give an order.
No, my lord, I will take
But then,
instruction regarding that refund.
Your client, they considered after the court's order and they said no vacancy, we are giving her MSCP benefit. She is retired 8 years back. The financial benefit, she has already got it. How can she claim dual benefit? Dual benefit she cannot claim. If she had got promotion, what is the financial benefit she would have got? They are giving her that.
I will have to take.
Probably you did not apply your mind in that way.
My lord,
See
I-
that. Dual you can't. So she has got the benefit of promotion.
But she has been systematically deprived from the.
Yeah, it is too late in the day to argue that. 2016, your client is retired. Now you cannot, what can be done on all these allegations? Nothing can be done. See, law operates in some well laid down principles, which we cannot tinker with. Do you want to take this back? These judgments are rendered on the facts of that. In this case, the petitioner was not considered,
Yes.
whereas juniors were considered. Your case is that I want promotion. They said no vacancy. So we give
No,
you
my junior
career, modified career progression scheme benefits.
My junior was promoted long time back, my lord.
But that
No,
is
my-
not the prayer here. That is not the prayer.
So I may be allowed some time.
All right,
Okay,
you take this back.
Yes.
Okay. Heard Mr. P.K. Goswami and counsel for the petition. I also heard Mr. You're appearing for?
For Health Department. Legal question will be.
We will understanding counsel for the health department. Should we admit this and fix it for hearing? No. No need.
That can be done.
On the request of Mr. Goswami, this matter stands adjourned for 3 weeks so as to enable him to obtain updated instructions. Mr. S. Dattal and his senior counsel has appeared for the private respondent numbers 3 to 9. Who are these private respondents?
They are serving now. They want over us.
My lord.
They want.
Authority over us. So that they can.
She is retired 8 years back. Absolute.
Must.
Lord, Lordships directed them to share the record. They have done it, my lord. From the record, what we find is, my lord, there is a worksheet, but there is no contemporaneous records. And first of all, my lord, when you say that, my lord, in the advertisement, there is no service rule. At the relevant point of time, when the recruitment was made, there was no service rule. Now, in the affidavit, they say a grade 3 selection has been made based on, my lord, interview. Lordship knows Government of India as well as Government of Assam has come up with clear circulars that in grade 3 and grade 4.
Mr. Chaudhary,
Yes.
Your junior has been allowed to inspect
Yes,
the record.
yes.
Is there anything you want to bring on
Yes,
record?
yes. On the records, my simple submission is, my lord, there is only a worksheet. There is a requirement of maintaining a contemporaneous record, which we did not find.
So would you like to file any affidavit to that effect, a short affidavit?
Oh, okay.
So that they can respond to it.
We'll do that. And secondly, my lord, all right, there's one more point, my lord. Now the selection was made only on the basis of interview. Grade 3.
Correct. So this coupled with the fact that no records are available, then we can ask them how to.
And then the Supreme Court has answered it in 86 supplementary SCC, my lord.
Why don't you file a short affidavit?
I'll do that.
How much time will be required?
My lord, we'll file by Friday.
No, but Mr. Chaudhary, every matter cannot be taken up. You understand that. Everybody wants, will file it tomorrow, give it day after tomorrow. The courts also have their own.
And after 10 days.
After 10 days. So you file the affidavit within 1 week?
Yes.
Mr. Kane.
But you can have it on not this Thursday, following Thursday. My lord.
But you will not be there. Your junior said another matter could not be fixed.
No, on Tuesday I'm not there.
Achha. All right.
Thursday is right. I think I don't know. Thursday.
Mr. Kane Chopin, Senior Counsel, assisted by Mr. P.K. Dekul, appearing for the writ petitioner submits that after the inspection of the record as permitted by this court by departmental record as permitted by this court by order dated 11/3/2025, the petitioners would like to file a short affidavit bringing certain facts on record. The prayer is not opposed by Mr.
B.
Gogul and Standing Counsel Health Department Assam. In view of the above, 1 week's time is granted to the petitioners to file the affidavit. Consequently, this writ petition is directed to be listed again on 27th of March 2025.
Item 5.
Item 5 and 6 would be similar.
The grievance of the petitioners are that they, having participated in a recruitment process as OBC category candidates, they were OBC category candidates, but they secured more marks than the general category candidates, but they were denied the selection under the unreserved category candidate only on the ground that they availed a relaxation in age. We impress upon Jitendra Singh's case to say that a relaxation in age or height, those which do not have any bearing on the merit, would not disentitle us from being considered as unreserved category candidates also. Respondents have not filed their affidavit on the issue till date. On the last occasion, an opportunity was granted, they have not filed an affidavit. If they do not file an affidavit, either we go by the doctrine of non-reverse and I go by Jitendra Singh's case. That is all.
Dispose it off then.
I have tried, but for filing affidavit, the staff selection commission have not given me any instruction. So
There
I
is-
can't file it. One affidavit I have filed by also think that from that selection process there is no vacancy. Is still there? No vacancy is there.
There is one hitch, my lord, which lordship.
How many petitioners are there?
My lord, in this writ petition, we have eight,
and second one 2, 9.
so there will be around 9 total.
Yeah, but one difficulty is then general category, the candidates
My lord,
were
my lord,
at the
when
bottom.
in a similar kind of situation, what the Honorable Supreme Court has suggested was creation of supernumerary posts to adjust these people if they fall in the merit. And later on, as and when vacancy arises, they will be shifted to the to those vacancies if necessary, because there was a wrong committed. One aspect of the matter, my lord, I must point out, the advertisement had said that those who avail relaxation in age will not be considered against the unreserved category. They will be clogged to the, they'll be returned back in the OBC category. Time of participation, we had not challenged them. Now it is after they implement that part, we have come before this court. But still, my lord, the fact remains that
So,
that clause was an
if you
illegal
would
clause.
not have come in under the age category,
My lord,
then under the relaxed category of age, then you would not have been a part of the selection process.
I would not have been a part of the selection process. True, my lord. And that is what Jitendra Singh has actually considered. The Supreme Court in the case of Jitendra Singh has considered and said that that was only to bring them to a level playing field, and their selection not being based upon their age or any other factor and being based only on the merit of the written examination. Once they get the merit.
But was there a restriction in that matter also? The advertisement, did it mention in Jitendra Singh that if you take the advantage of age while participating, then you will all along be treated
My
as.
lord, in Jitendra Singh, that was not consideration. That was one of the consideration in Deepa EV's case, where the Honorable Supreme Court that if there is a clause, they had differed from the judgment of Jitendra Singh, but also observe that since that OM or that part of that advertisement was never challenged, therefore the respondents could, the petitioners could not take the advantage. In our case, we have challenged that clause. We have challenged that advertisement, that clause of the advertisement.
Which clause of the advertisement? Let us see.
Lordship would find it at page 40. I'm sorry, madam, not page 40. 44.
You are referring to which writ petition?
Both the writ petitions, my lord.
Oh, you can't show page 44 of both the writ petitions. Huh?
WBC 4.
Item 5.
4288.
Yes, 44.
You are referring to page 44.
Yes, page
All right.
44. Clause 11.
Clause 11.
Subclause 13. 13 of clause 11. Page 44. Lordship will find Roman 13 in the middle.
All right.
That is part of clause 11.
All right. Please read it.
SC, ST, OBC and ex-servicemen candidates who are selected on their own merit without relaxed standards, along with candidates belonging to other communities, will not be adjusted against the reserved share of vacancies. Such candidates will be accommodated against the unreserved vacancy as per their position in the overall merit list. Reserved vacancies shall be filled up separately from amongst the eligible SC, ST, OBC and ex-servicemen candidates. 14. SC, ST, OBC and ex-servicemen candidate who qualify on the basis of relaxed standard, that is age limit, height, chest measurement, experience or qualification, permitted number of chances, extended zone of consideration larger than what is provided for general category candidate, etc. Irrespective of his or her merit position, such SC, ST, OBC an ex-serviceman candidate is to be counted against reserved vacancies. Insofar as the cases of ex-servicemen are concerned, deduction of military service rendered from the age of ex-serviceman is permissible against the reserved and unreserved post, and such exemption will not be termed. The first part is what?
So why were they
troubles
not
us.
appointed as reserve category candidates?
Because my reserve category cutoff was more than that of the unreserved category. What happens is, my lord, reserve category candidates, they come of a higher age. So they score more merit. But that is the system that has been followed. Therefore, I'm challenging in my lord. What happens is a reserve category candidates of 27 years of age secures 50. Cutoff remains at 50, the last candidate. For unreserved category, the persons are younger in age. They are 23 years of age. So in the merit position, they sometimes come to 44. Unreserved gets cut off at 44. Reserved gets cut off at, OBC gets cut off at 50. SC gets cut off at 55. That has been happening all throughout in all the selection process. Just because this portion of the advertisement does not allow meritorious ST, SC, OBC candidates to come to the unreserved category. This clause is exactly against what Jitendra Singh had said. Had Jitendra Singh been scrupulously followed,
So this is, this selection is of
the
what?
CAPM, constables in the Central Armed Police Forces.
We'll hear the matter. This is not something to be
Yes,
decided in
madam.
admission. We'll
And
admit.
in the absence of the
implemented-
affidavit, it will be a bit perhaps.
Heard Mr. R. Majumdar and the counsel appearing for the writ petitioners in both these writ petitions. Also heard Ms. B. Sharma, learned CGC representing the respondents. Having heard the preliminary arguments advanced at the bar, this court is of the opinion that the matter would require detailed hearing. As such, admit the writ petitions. Since the respondents are already represented, no formal notice is required to be sent in this case. Register to list this matter for final hearing on a non-miscellaneous day in the month of June 2025. Or it can be even later.
They with their appointments, my lord. They were already overaged when they
Any
applied.
difficulty if it is postponed a little more? No.
But let it be on June, my lord.
In the month of July 2025 on a non-miscellaneous day. In the meantime, the other respondents would be at liberty to file counter affidavit if so advised.
Colleagues were requesting for a little earlier date. Could it be June, my lord? June itself. I'm obliged. 5 and 6 would be similar. my lord.
5 and 6, item 5 and 6. Same order together.
Item 8. What to 8 means?
I beg to appear for respondent numbers 2 to 8 in the matter. The petitioners filed an additional affidavit after the last date of hearing on the 6th of February. I have filed my reply, which is before the registry, my lords. In fact, in the morning, my colleague had mentioned it, requesting my lords to have that reply taken on record to the additional affidavit that they have filed after the last date of hearing. my lords. My only request is that reply be taken on record before the hearing. my lords.
Have you received the reply?
We have served it.
Lord, this is a matter where the petitioner, who is of the rank of Deputy General Manager, my lord. He has been superseded insofar as promotion to the grade of General Manager is concerned in 2023 and 2024. My lord, basically we are praying for a disposal of this case because, my lord, on 2 occasions he has been superseded. Now, my lord, the criteria of promotion, as I find from the policy of the insurance company, though it is not clearly stated, it's not a pure merit cum seniority criteria. It's a, my lord, criteria where, in my humble submission, subject to what your lordships may say,
yes,
it's a merit and suitability with due regard to seniority. Now, my lord, I am claiming my promotion not only on the basis of seniority. Undoubtedly, I am the senior most. On merit also, I do not lag behind. Their affidavit is very, my lord, cryptic as to why we have made specific amendments in the petition saying that this is the merit, this is my seniority. How come my case has been ignored? They give evasive reply, my lord. So therefore, end of the day, it is the records which will bear out the case.
So you are appearing for whom?
I am appearing for respondent numbers 2 to 8, the insurance companies, my lords, as well as GIPSA.
And the records are there with you?
The records are already filed on record. I filed my counter affidavit. The promotion. Sorry, my lords.
The question is not whether you filed your counter.
Sorry,
You have the departmental records.
The DPC minutes.
The DPC records are not with me, my lords. I most respectfully, my lords, just from what my learned senior just said. This we are talking about the post in the scale 7 cadre. This is the highest cadre from which is the feeder cadre for the CMD post, my lords. After this cadre directly the CMDs of the companies are picked up for all the general insurance, public sector insurance companies, my lords. This promotion exercise from scale 6 to scale 7 is solely based on merit. Seniority aspect only comes until the officers are jotted down under the zone of consideration. So seniority, of course, with their existing service and their balance service only and only qualifies them to fall under the zone of consideration.
All right.
And subsequent. That's right.
Just a minute. You see, this could be your projected case, and there is no difficulty with that. So what you are saying is your seniority will count only to bring you within the zone.
That's right.
But once you are inside the zone, anybody can be promoted.
Absolutely.
Depending on merit.
That's my case.
So there must be a criteria. The DPC must have laid down this.
The promotion policy is absolutely clear on that criteria. In fact, my lords, the promotion policy specific to this cadre has only 2 aspects.
So,
after the zone,
just a minute. The petitioner is aggrieved by the last DPC. When was it held?
In 24-25, which was the result was. Sorry. Well, the result was issued on 8th of February 2024. Sorry, 14th of February 2024 minutes.
Okay. So then why don't you produce the minutes of the DPC and we'll have a look at it and see if the criteria is transparent. Will end the matter ends.
Exactly.
Well, I think there'll be a difficulty there. Why I'm saying this is this. Please, Manoj. There are only 2 aspects to this. The one, there is a screening committee, which is not me. It is an independent body, the Staff College of India, which conducts the screening. And thereafter, a subjective interview is conducted by a committee of all of the CMDs of the 6 general insurance companies, which are public sector. This is a subjective decision which is taken by the screening committee to say if the candidate has qualified, has screened in for the interview purpose, and thereafter the interviews are conducted by the committee of the CMDs. Thereafter, the result is declared. From what I understand, my lords, and which is the case that I'm going to put forth, there is going to be no marking of specific areas because this is a generic selection based on the overall merit of the candidate, number 1, my lords. And number 2, this is not a secluded consideration of this particular candidate's merit. It is going to be a comparative analysis between the merits of the candidates available with the company versus the vacancies which are to be filled in.
So, Mr. Your name, please?
Zoravar Singh.
Mr. Singh, the petitioner is saying that he has been ousted or deprived from promotion on criterias or on considerations which are not bona fide.
That's right.
How is the court supposed to give a verdict to this unless the records are seen?
Then may I say,
you have to either say yes or no to his question.
So, I'll say 2 things. One, the petitioner participated in an exercise the previous year under the same policy, same amendments, same rules of the company, did not go through. He was in the zone of consideration, did not qualify after the interview, did not challenge that result. The second year, under the same policy, same rules, when he does not qualify, he challenges it because thereafter, now because of the prevalent provisions of the promotion policy, because 2 times he has superseded and now he does not have the balance 2 years service remaining, which qualifies him to sit for this post. Now is the only reason that he gets aggrieved by it. That's number 1. No, I agree, Manoj.
Either you say that the records cannot be produced.
No, I'm not saying that. If Manoj will direct, I'll get the records.
Then you get
I'll get the records.
We'll finish it off.
I'll take insight.
Most interestingly, what is the subjective satisfaction?
First time I'm hearing I can read out the policy.
No. What is the subjective satisfaction? I'm at a loss to find out, my lord. What is the meaning of subjective satisfaction? I said this is not white, this is black. So that is my subjective satisfaction.
Manoj, may I just say one thing? Just one thing. Manoj, today, by what is flowing from my lords and perhaps the direction which will be passed today, and I have no difficulty, I'll get the records. I will stand in every court in every state to basically satisfy the conscience of a candidate who has not made it to the final list. Only because I have to tell them that at a higher position of the highest possible position of scale 7 from where, which is a feeder cadre for the CMDs, why subjectively I have not chosen you and I have chosen others, Manoj. Please see the Pandora box that this will open if I stand as an executive this after my policy is in place. See, he has not challenged the promotion policy. If the prayers of the writ petitioner seen, he has not challenged the promotion policy. He only says, I have not been selected. I should have been selected under this
The
policy.
promotion policy, what is it permissible that subjective satisfaction?
That's right, Maloj. Let me show that, Maloj. For Maloj, if Maloj can have my counter affidavit, I have reproduced the relevant provisions of the promotion policy.
Yes.
My counter affidavit at page 160, Maloj.
Yes.
Paragraph 11.
Yes.
Maloj, clause 5.1. Only to show promotion of officers from scale 5 to scale 6 not relevant, and from scale 6 to scale 7, which the petitioner falls under, shall be within the 4 GIPSA member companies and GIC taken together. This has become now 6 months. For this purpose, all officers in scale 5, in all the 5 companies will be taken together and shall be ranked in a single seniority list to be maintained by GIPSA. Similarly, a single seniority list for all officers in scale 6 in all 5 companies will be taken together as maintained by GIPSA. This is the consideration of all.
GIPSA? What is
GIPSA is just an informal body created between the insurance companies for ease of coordination, because there are 6 insurance companies now. It is an informal body, even according to my learned
These are all public sector insurance companies.
Yes, that's right, Manoj. All public sector insurance companies. Now let's page 161. This is the criteria and very important.
Yes.
Malaj, page 161, para 12. I have reproduced clause 7 of the promotion policy. Relevant is 7.2, Malaj. While promotions to scale 6 and scale 7 shall be based on the sole criterion of merit. Seniority does not play a role here, Malaj. Just the merit, Malaj. Then, Malaj, comes 8.1 at paragraph 13, Malaj, which there is a requirement of the exercise. There is a certain service that needs to be there in the existing cadre, and post there should be a balance service of 2 years. That sets out the eligibility criteria for an officer of this cadre to fall under the zone of consideration, Malaj. And then, Malaj, comes what just flowed from Malaj at page 162, clause 9.1. Malaj, have that?
Yes.
9.1, second paragraph. This is the screening committee, Manoj. The screening committee shall assess the officers under the parameters of conceptual level / vision, depth and range of overview of the industry / economy, planning ability, decision-making ability, management traits, positive attitude, problem-solving ability, including conflict resolution, management, overall leadership ability, etc., and submit their assessment recommendations to the promotion committee. So therefore, it's entirely subjective. The screening committee, which is a third-party committee sitting outside.
Mr. Singh, please listen to this.
Absolutely.
Your response will be very important. You see, this is a promotion. This is not an appointment by following the doctrine of pleasure.
That's absolutely.
It's not the pleasure of any insurance company. These are all companies which are public sector undertakings, and therefore they come within the meaning of Article 12 of the Constitution. These companies will have to function by adhering to certain norms of transparency. Correct? Now, when you have a promotion policy, a criteria, if an officer is aggrieved or comes to the court by making an allegation and a prima facie case is made out, the court would like to see what is the criteria you have followed. If you say that, sorry, it's all subjective, we'll not say why we have picked X, why we picked Y. The liberty that you have is to set any criteria that you want. But you can't say that we will not set any criteria. Then it becomes a process on ipse dixi. In that case, if somebody comes to the court challenging, we have not asked him to come. He has come to the court. He is aggrieved. Twice he has been superseded or ignored. The court has to give an answer to his grievance. So the only way to give an answer is examining the records and saying that, sorry, your case is not made out. Or the otherwise. It cannot be said that because it is a completely subjective process, you have no remedy. Because whether you are promoted or not, you will go without a remedy. please answer that query of the court. What is the stand of your client? That after you come in the zone of consideration, rest only these 6 people in the interview, board knows what it is, and we are not going to disclose. That is a stand you can make it if you are a private company. But in a public sector, sorry, because in any case, you are coming within the ambit of Article 14 and 16.
So therefore, my lords, my reply will be
You
two.
have to. If you have not done it,
I
it could
absolutely
be a
understand.
case of striking it out at policy.
I absolutely understand what's
You
flowing.
can't follow arbitrary policy and non-transparent policy.
That's right. Most
That
respectful.
gives you completely unfettered powers.
That's right.
There can be, that is not how anything happens in this country.
Absolutely.
So if that is your policy, that's your prerogative, help it.
That's right.
So you said that, do you go to every state only because the conscience, if they make out a case, you will have to. You will have to go.
My lords,
That
perhaps
is
my
the constitutional mechanism.
absolutely agree. My lords. Absolutely agree. Only one small submission. Article 16 and what judicial precedents on Article 16 up till the Supreme Court says is this, minutes. Equality for consideration is enshrined under Article 16 minutes. Equality for consideration minutes, and therefore there is no difficulty on equality of consideration. The eligibility criteria of these officers, in fact, not only this petitioner, all of the officers.
No, you
similarly
missed out on Article 14. Article 14 speaks about non-discrimination.
Absolutely does.
So after
Absolutely.
senior officer is saying, I have been discriminated.
Absolutely.
Show us that he has not been discriminated.
So therefore, my lords,
instead of that, you are saying that there is a process we can't tell anyone.
no, my lords, absolutely not. Absolutely. No, so therefore, my lords, the only question which I may ask myself is this, my lords. If there are 10 vacancies, for an example, my lords, and if there are 40 qualifying officers, my lords, and they're all meritorious, after all, they're all senior officers. There is no way I can say that any single officer at that level and that cadre is not meritorious, my lords. But if there are only 10 vacancies, then there are 40 people eligible under the zone of.
I'm sorry. These arguments are not.
I will get the record. I'll get the record.
We are not saying you should say somebody is not. We are only asking you what is the criteria.
I'll get the record. I'll take instruction. I'll file
Tell him that you have not been you have not been treated with any sense of discrimination. That's all.
My lords, may permit me to file an affidavit. I'll place it on record.
My lord, can I just come? Kindly give me 2 minutes time. Please come to 177, their affidavit, my lord. And I'll place the para 13 of that policy also. I think the writ petition needs to be allowed today, my lord. Because on oath, they are before a lordship saying it has gone by subjective view. Please come to para 40. Contents of para towards the bottom of page 177. The contents of para 12 of writ petition needs no reply. It is respectfully submitted that by way of its representation as well as RTA application, the petitioner is attempting to monitor the conduct of promotion committee, which cannot be permitted to be allowed by this honorable court. The petitioner is not at liberty to seek explanation from the company for not promoting him to top management cadre when promotion policy specifically provides for merit as the sole criteria and not just seniority. It is submitted that promotion at such higher level are subjective. Nothing further is required, my lord. Now, one more thing, my lord. Please come to page 211, the policy. Clause 13.1. Now, whether it is subjective or it is objective, my lord. Eligible officers after being interviewed by screening committee as per para 9.1 shall appear for an interview by promotion committee. Committee shall, after taking into account the assessment, recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, experience in various functional areas, and seniority, kindly see, and seniority of the candidates as may be assessed from performance appraisal record as well as personal interview. Prepare a list of officers selected for promotion. If this is the understanding.
I follow. Mr. Singh, you see, that could be, we are not here to give an advice, but even in an extreme case, subjective satisfaction can be there, but it has to be an objective criteria.
Materials.
And show us what is the objective material on which the subjective satisfaction has been.
I understand. I'll file an affidavit.
That it's okay. Otherwise, it becomes completely arbitrary exercise.
I completely understand what.
And then the allegation of malafide discrimination is prima facie.
I follow what my lords. I follow.
That will be malice in law.
I follow. I'll file an affidavit.
You will file an affidavit.
And I'll place on record what needs to be there.
Lord, they are not bound to produce the records. If they don't produce, Lordship will draw adverse conclusion. It's a certiorari
That's all
procedure.
right.
That's fine. Let
he
me take
might-
instructions. I'll file a paper.
You might need some instruction on that. How much time do you need, Mr.
Just 3 weeks.
Chair?
It's a public sector
It's-
insurance company. It's at least 3 weeks.
All right, let it go after vacation.
Yes,
Please.
after due vacation, Lordship will kindly give a date.
All right, I heard Mr. K. N. Chaudhary, Learned Senior Counsel appearing for the also heard Mr. Z. Singh, Learned Counsel appearing for all the respondents.
Respond numbers 2 to 8, my lords.
Respond numbers 2 to 8, who seeks posting of this matter again after the Bihu vacation so as to enable him to obtain updated instruction and if necessary file an additional affidavit responding to the query of the court to lay down the relevant records indicating the objective materials based on which the subjective satisfaction has allegedly been drawn while promoting the candidates involved in this exercise. Full stop. Ms. K. Fukan, Learned CGC, is present on behalf of the respondent number 1. As paid for by Mr. Singh, let this matter be listed again on 6th of May 2000. Is it okay? 6th of May? 6th
Highly
of May?
My lords, I'm extremely sorry, my lords. Can it be 8th? Can I please request for it? Highly obliged.
There's an interim order that will continue.
What is the interim order?
One post to be kept.
Interim order first to continue.
Deeply.
Highly obliged. Well, it's just one small request, my lords. My name does not feature either in the cause list or in the order sheet, my lords, if that can.
That's a serious lapse. Any penalties to be imposed by reflecting the name of Mr. Z. Singh, Learned Counsel for the respondents to.
I'll give my full name, my lords, please. Highly obliged.
Rest of the matters are 2. Yes, Mr. Majumdar, anything happening here or should we?
It just
My
first
last
point.
yes.
Plus, last occasion, my senior has presented one communication. My lord, there were 4 points, my lord. No, I am concerned with only point number 1 regarding my lord providing the journals. Others are, my lord, the state has said that they will take care of those things. But my instruction is that as of now, the journal has not been furnished. There is no order by the judicial department. Although Home and Political Department had directed the judicial department to take care of that thing. But no journal has been furnished as of now. That is my instruction.
But the state has agreed that.
Agreed. There is, Milord, there is no dispute that state has not agreed. State has agreed, but it has not, yielded to anything. It has not been implemented. Although decision has been taken, it has not been implemented.
No, they will do it manually. Once they have taken it, they will provide
No,
it.
but this is a judicially monitored proceeding, so it can't be like.
No,
they
my
do
lord.
Whenever they feel like, there has to be some clarity, no?
My lord, on the last occasion, I produced one document
So
where
February.
it is of 5th of February. They have already said that they have GLR and GLT they are going to provide.
And the other books.
GLR, GLT. They are going to providing for 2 local
where is
journals,
that?
namely
Where
GL and
is that?
GLT. The document I'll produce on the last occasion
It's
itself.
a letter by
Document. I think it is on record.
political department to the government advocate.
I will produce my copy, mine. Second paragraph.
Training too.
And why you have nothing to do with the other issues?
Yes, my lord. The 4th issue is also important. I'm sorry, my lord. 4th issue is also important. The training one, my lord. Training one is important, my lord.
Yeah, but you said you have nothing.
No, I'm sorry, my lord. I beg apology, my lord, for that. My lord, training, my lord, my senior has to produce instructions. What happened to that?
Before the next day, I'll produce all the. Because my instruction is everything is in order. They are doing it. They are proceeding. Overnight, it will not happen, my lord.
Who is asking things to happen overnight? What is the meaning of overnight? How long? Say 2, 3, 4 years, something like that.
There may be a question of budget, etc. But there, once they have said they will provide GLT, GLR, GLT.
Acha, you please take back this copy.
I'll find out the present status with regard to training whether because they have given the name also of the resource persons. Honorable Justice P.K. Deka and B.K. Sharma, UK Nair, they have already talked and they have finalized. They will come.
They are sitting judges.
Yes.
Justice UK.
Only Justice UK, yes.
How can he go? He's a sitting judge.
No, my lord. Those may kindly see the paragraph 4. The need to provide training to the members of the FT. In this regard, it may be stated the matter of providing training to the members of all foreign tribunals is already under consideration. The matter has been taken up with Honorable Justice B.K. Sharma retired, Honorable Justice P.K. Deka retired, and Honorable Justice UK Nair of the Honorable Court for conducting the said training on a suitable date. They will be requested.
Justice B.K. Sharma, Justice P.K. Deka, we can understand.
My lord.
How sitting judges can. Will it be proper?
They have approached, I think, if Honorable Justice P.K. UK Nair is unable to go, then maybe they will conduct it with.
It's not a question of able or unable. Then why don't we also give training to the police how to conduct investigations?
I'll find out.
Judicial matters have got certain element of propriety which are matter of public perception.
This does not reflect whether any consultation has been made or not.
They simply say the matter has been taken up with them. I'll find out the present status and I'll let you know.
It has to be reviewed.
I'll let you know.
Make it clear to them.
My lord. I'll bring it to
When
them.
sitting judges, they are hearing cases and then.
They cannot.
Because these members are not strictly judicial officers.
Yes.
They are actually executive functionaries.
Lordship is correct.
Quasi-judicial functionaries.
Possibly.
So tomorrow, if an allegation is made that they are deciding as per instruction given by the High Court on the administrative side,
Correct.
it will lead to a very bad, embarrassing situation.
Yes.
Because what Justice Nair says, they will be bound to follow. It is not the case with other judges. So there is, I'm not saying this will happen. I'm saying if a perception is created, how does the High Court deal with it? Sitting judges are not supposed to give training. If it is happening anywhere, it's a wrong thing happening. Sitting judges can address a gathering on overall perspective of how the institution
I'll convey.
is perceived. But training means to tell the officer, do it in this manner, that is the right manner.
Yes.
No judge sitting and discharging duty in the jurisdiction area should give. If it happens, it is an improper thing at any level. Any level, any institution, if it is happening, a sitting judge should not actually give training to even to judicial officers. Because he will be transmitting his own, or she will be transmitting his own point of view in a matter.
Own ideas.
The judicial officers will try to stick to that, rightly or wrongly sometimes.
We
Achha,
have so
there
many,
is, sorry?
look, we have so many retired judges.
That's
here-
right. That's
here.
the idea. It's not that anybody will lose his or her objective.
Exactly.
Not that.
Exactly.
It's not that a sitting judge will go and say something which is not in the right perspective, but it's a question of perception. It's a question of perception.
Yes.
Yes.
All right, we'll defer, but Mr. Majumdar, this cannot go on like
I'll find,
this.
yes, yes.
It has to.
GLR GLT has to be provided immediately. I'll convey.
And see, these are, we don't want to pass strict orders.
No, no.
We trust the officers
Lordship
are
will
doing
not.
their job. So let it remain at that level. These are pushes and nudges to see that institution. We asked a query, the state said we'll do it. The state has itself identified which journal.
True.
It is all about now implementing it. Otherwise, what is the point in this exercise? Achha, having said this, there is another aspect which both sides, I would request all of you.
Yes, ma'am.
There is a latest judgment of the Honorable Supreme Court that is on challenge made to Section 6A of the Citizenship Act.
Yes.
Most probably. Now, there is some monitoring to be done by some court as per that judgment. Have you examined that judgment? Is it something which is required to be, any exercise is required to be done by this court pursuant to that judgment? Is there anything?
We'll have to,
Huh?
I'll have to go through, Miller. I haven't gone through.
I have a copy of the judgment.
You have a copy. It's a voluminous judgment.
It's a
Voluminous. I have
But,
got in the software.
Some
Some
monitoring,
directions are
some
there. at
monitoring
the
guidelines are
end.
there.
Yes, ma'am.
So is there any guideline for the High Court to follow there?
Possibly not, my lord. As far as I recall,
Hmm.
uh, that is with regard to the existing tribunals possibly. I'll just get the copy, my lord. Yes.
So please examine it,
My
not
lord.
today, maybe on the next day.
Yes.
I'm not putting it in the order,
My lord.
but please examine and address the court. If there is a direction of the Supreme Court, we have to do it. If it is not there, then no question.
Possibly not, my lord. Still, I'll get a copy and I'll let you. In the last part of the judgment, there are some directions. Your lordship is
Anything
correct.
to do with the High Court,
Possible.
Guwahati High Court here?
My lord, I'll see. Possibly nothing to do with the monitoring bench. As of now.
But anything to do with the High Court?
No, not possible. I'll just.
Mr.
I-
Das?
I'll check and verify. Miller, it's not opinion, Miller. This is a voluminous judgment.
That's all right.
So I'll just check and.
I thought you would
address-
be ready with an answer today. Huh?
My
What is
apologies.
Mr. Das doing is.
My apologies, Miller.
Yes, yeah. No. No.
So what is to be done?
Lordship, I'll come up with the updated status of all these matters regarding training, supply of books. Lordship, fix it for 3-4 weeks. I'll come up with latest position.
Last.
September. Good profile do you have? Not have time.
You have to write the names of everyone. Can you do it? Or Mr. H.K. Das and Mr. A. Das, learned amicus curiae. Appearing in this case, also heard Mr. D. Majumdar, learned senior additional advocate general Assam. Assisted by Ms. M. Bhattacharya, learned additional senior government advocate Assam. Appearing for the state of Assam. Mr. R.K.D.
Let us see
Chaudhary,
there are
learned
little bit of
DSGI is
policies of
present
the-
for the Union of India. Which respondent number 4 is? AG. What has AG Accountant General got to do here? Which case you are appearing?
EG?
Foreigners bench.
Question of 4.
Is the Accountant General a party in this?
Lord, yes, initially perhaps when it was started.
What is Accountant General got to do? What accounting is required here? Accounting of cases disposed of? I have not understood. I don't think Accountant General is a party.
Nothing is reported.
You are relieved of yours. The learned amicus curiae has invited the attention of this court to the order dated 6/2/2025 passed, as well as 7/1/2025 passed in this proceeding to submit that concrete steps are yet to be initiated by the state towards implementation of the suggestions to proposals made. Suggestions and proposals pertaining to the 4 issues identified by the court. Full stop. Mr. D. Majumdar, learned additional AG Assam, has referred to a communication dated 5/2/2025 issued by the Joint Secretary to the Government of Assam political bracket B bracket close department dispute to submit that all the 4 issues have been examined and the government has accepted the proposals in principle. Full stop. No, the government has accepted these suggestions of the learned amicus curiae in principle. Not only that, Mr. Majumdar submits that 2 journals, namely GLR and GLT, have already been identified for providing the same to the learned members of the Foreigners Tribunal and resource persons for imparting periodical training stroke refreshers course to the members of the FT are also being worked out. Full stop. However, since these issues are associated with some operational problems, Mr. Majumdar seeks 1 month further time to obtain concrete instruction and appraise this court as to the steps that have been taken for implementing the measures for addressing the 4 issues raised in the order dated 7/1/2025 passed by this court. No, not 7/1. 4 issues identified. Which are the 4 issues identified? These are 4 issues referred to in the communication dated 5/2025. On the request of Mr. Majumdar, let this matter be listed again on 5th of May, 2025. A copy of the communication dated 25/2025 be retained in the record.
And I've got a copy of the judgment of Supreme Court.
Yes.
I'm just reading the last part, conclusion part, man. I summarize my final conclusions as follows. A. Immigrants who migrated before 1/1/1966 and were conferred deemed citizenship on the date of commencement of Section 6A2, subject to fulfillment of all conditions mentioned therein, shall remain unaffected. B. Immigrants who migrated between 1/1/66 and 24/3/71 and have been granted citizenship after following the due procedure prescribed under Section 6A3 shall remain unaffected. Immigrants who migrated between 1/1/66 and 24/3/71, both inclusive, and who have been detected as foreigners and have registered themselves with the registering authority as per the prescribed rules, shall be deemed to be citizens of India for all purposes from the date of expiry of the period of 10 years from the date on which they were detected as foreigners. D. Immigrants who migrated between 1/1/66 and 71 and who have been detected as foreigners but have not registered themselves with the registering authority within the prescribed time limit as per Citizenship Rules 2009 will no longer be eligible for the benefit of citizenship. This is important. And E. Immigrants who migrated between 1/1/66 and 24/3/71 and whose applications are pending for adjudication before the Foreigners Tribunal or who have preferred any appeal against any order of such tribunal which is pending before any court will continue to be governed by Section 6A3 as it stood immediately prior to the pronouncement of this judgment till their appeals are disposed of. And lastly, F. From the date of commencement of the judgment, all immigrants in the state of Assam shall be dealt with in accordance with the applicable laws, and no benefit under Section 6A shall be available to any such immigrant. To be precise, if someone is apprehended as an illegal immigrant after the pronouncement of this judgment, Section 6A of the Citizenship Act will have no application. These are the directions.
Nothing on monitoring. Okay. All right. Next matter.
Much obliged.
For hearing, item 11.
Very good.
Matter of contractual appointment is challenging the regular selection process.
Go and type this.
Only one point, Lordship. Lordship, in page number 47, Lordship, it is clear from page number 47 that the post he was holding was substantive, Lordship.
Just a minute, you take your seat, I'll come back.
Lordship.
What has happened to WBC 4642 of 2017?
Lordship,
Is
that
it
was
listed?
no, that was withdrawn with liberty because during pendency of that writ petition, selection process was completed.
So your client is a contractual appointee.
Yes.
And that contract has been extended from time to time.
Yes.
Now, what does he want? He could not participate in the regular process
Lordship,
because he was overaged.
Overaged. Yes. Though he made representations to email, but he was not allowed to participate.
But that chapter is over.
Yes.
Now, today in this writ petition, what is that you want?
Lordship, we are relying on a Supreme Court judgment, Lordship.
No, first tell what you want.
Lordship, the petitioner is seeking regularization, Lordship. The petitioner is seeking regularization because the period which he has spent in the in Oil India as a pipeline engineer is more than a decade, Lordship. And he was holding a substantive post, Lordship. If we see page number 47, Lordship. First, second. So here, Lordship, 1, 2, 3, 4.
So he was appointed in 2007.
Yes.
He's still continuing.
No.
Then?
His contract was expired on 18/11/2017. So that was not renewed.
18/11/2017 contract
Yes.
is expired.
Yes.
Page 47 would indicate that particular date, page 47.
Then what remains in this case now, Mr. Acharya?
Lordship,
If he was continuing, then we could have thought of some mechanism, but he is already out. He cannot be regularized. This is your misunderstanding of law. A contractual employee cannot be regularly observed against a regular vacancy. But the court can certainly mold relief if somebody has worked for so many years. But then he has already been, have you challenged this order, 18/11/2017? Is it under challenge?
18/11/2017, they have not passed any order as such.
All right, you conclude your argument.
Lordship.
There is nothing that can be done in this case.
Yeah, Lordship, since the Tengakhat pump station operates in shift duty.
You forget all these things. What is the legal principle which supports your plea? Your client was on contractual appointment.
Yes.
The terms and conditions of appointment are laid down in the contract.
Yes.
Whatever reason, he continued till 2017, and then the contract was terminated.
Yes.
The service was brought to an end. Correct. So
Yes.
the relationship between employer and employee had ceased in
Yes.
2017. It's not something one would appreciate, but it has happened.
Yes.
Now he is out since last how many years? 8 years.
Yes.
Now you want him to be regularized. It cannot be done. So you conclude early. Don't waste time of the court unnecessarily. It's a completely unmeritorious case here. It cannot, no such mandamus can be issued. There is no such principle of law.
Lordship.
That's the whole long and short of the matter. There is no Supreme Court judgment which supports your case. It could be a misreading of the judgment or misunderstanding. I don't know. And you are appearing for whom?
Oil India Limited.
Respondent numbers?
Respondent number 228.
228 and 209 to 12.
They are the appointees pursuant to the 2017 selection process. The basic challenge herein is, in 2017, there has been a regular selection drive. Now he challenges that, asking for a setting aside of that selection process. And his prayer number 2 is, therefore, to regularize him and then to compete with the other regular employees there. That is his prayer. If Lordship sees the prayer, his prayer is twofold. Number 1 is challenging the selection process without having participated in the same advertisement. And the number 2 is regularization, wherein he is otherwise a contractual employee based on certain contracts. Every year when it was extended, there was a gap, and then it was extended, there were a contract signed. And the very recruitment process through which he entered was a purely contractual. It has been categorically stated therein that this will be a purely contractual assignment.
Where is his order of appointment?
If your Lordship will come to page 30 of the writ petition. Before that, page 23 is the advertisement.
Page 23.
Page 23.
Page 23 is part of the writ petition.
Yes, the writ petition only. I'm part of the writ petition. Annexure 1, Lordship.
No, it's a part of the pleadings in the writ petition.
No, after the affidavit, Lordship. Affidavit is page
Okay.
22. Page 23 is the Annexure 1.
That is the original advertisement by which he was.
Yes, Lordship.
Yes, what does it say?
I'm just reading. Oil India Limited, a premier public sector undertaking, engaged in exploration, production, and transportation of crude oil, natural gas, and manufacture of LPG, intends to engage experienced mechanical engineers on contract basis for purely temporary requirement of oil or pipeline expansion project from Numaligarh to Siliguri. So that was basically a project. The contract would be for a period of 1 year or till completion of the project. So based on this particular advertisement, which was purely meant for contractual, he was appointed for 1 year. And then subsequently, yes, because the project was not completed, there were separate orders of contractual reassignments. And agreements were signed every time that assignment orders were given, wherein the period was indicated. And it finally ended on 18/11/2017, whereby the contract has ended. And today he is no longer in service. His claim in the writ petition is the regular recruitment drive has to be set aside, and he should be regularized in that place. He doesn't even participate in that process.
And where is the advertisement for the regular recruitment drive?
Page number 48. Page number 48, Lordship.
Yes, page number 48 and Exercise 7. And the concerned post would be third. Post name and code, item number 3. In the column, the third one. The third row.
And in page number 49, Lordship, the post qualification experience is provided. Page number 49, serial number 3.
So in that process, it has culminated. Appointees have now are working, and my senior is representing them, Your Lordship.
That process has been completed.
Completed, and they are working now. Those employees are working there, and my senior is representing them.
And the post qualification experience, Lordship, page number 49.
No, these are not relevant here. The relevant is you don't have a right which can be enforced. That's the sad part of it. What can be done? Your client was aware that it was a contractual appointment.
Yes.
Now what you're seeking is totally illegal. That the court cannot grant you.
And every time he has signed the agreements.
You have understood. Now what judgment you want to show?
Lordship, that is Jaggo versus Union of India.
Copy of the
All right. What is the point? What is the decision
Lordship,
here?
even Lordship, in that case, Lordship, certain Safai walis were appointed on ad hoc basis. So the Honorable Supreme Court has ordered for reinstatement of those Safai walis and also directed for their regularization.
No, but they are not contractual employees.
They were contractual employees, Lordship.
The ad hoc basis you are saying, how can it
Yes.
be? Ad hoc and contractual are two different things.
They were appointed in 1998. Probably Uma Devi was put into application. Appointees of 1990.
That's a different thing. These are, tell me the facts correctly, na? He's totally confusing everything.
Engaged by Central Water Commission on part-time ad hoc terms.
Govinda Sharma, call him Govinda Sharma. Tell him to come.
Relevant portion is from para 20. Shall I read, Lordship?
Uma Devi.
It is well established that the decision in Umadevi Supra does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and humane resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar and others, etc., versus Union of India and others, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary but has performed the same duties as performed by regular employee over a considerable period in the capacity of regular employee. The relevant paras of the judgment have been reproduced below. The application of the judgment in Umadevi Supra by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and a subsequent circular, followed by a selection process involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry, as discussed in the case of Umadevi Supra. The judgment in the case Umadevi Supra also distinguished between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedures of regular employment, such as conduct of written examinations or interviews as in the present case. The High Court placed undue emphasis on the initial level of the applicant's engagements and the outsourcing decision taken after their dismissal. Courts must look beyond the surface levels and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointments. In that light, refusing regularization simply because their original terms did not explicitly state so, or because an outsourcing policy was belatedly introduced, would be contrary to the principles of fairness and equity. The pervasive misuse of temporary employment contracts, as exemplified in this case, reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trend observed in the gig economy, but also sets a concerning precedent that can erode public trust in government operations. The International Labour Organization, of which India is a founding member, has consistently advocated for employment stability and the fair treatment of workers. The ILO's multinational enterprises declaration encourages companies to provide stable employment and to observe obligations concerning employment stability and social security. It emphasizes that enterprises should assume a leading role in promoting employment security, particularly in contexts where job discontinuation could exacerbate long-term unemployment. The landmark judgment of the United States in the case of Viz Canio versus Microsoft Corporation serves as a pertinent example for the private sector, illustrating the consequences of misclassifying employees to circumvent providing benefits. In this case, Microsoft classified certain workers as independent contractors, thereby denying the employee benefits. The US Court of Appeals for the Ninth Circuit determined that these workers were in fact common law employees and were entitled to the same benefits as regular employees. The court noted that larger corporations have increasingly adopted the practice of hiring temporary employees or independent contractors as a means of avoiding payment of employee benefits, thereby increasing their profits. This judgment underscores the principle that the nature of the work performed rather than the label assigned to the worker should determine employment status and the corresponding rights and benefits. It highlights the judiciary's role in rectifying such misclassifications and ensuring that workers receive fair treatment. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations or to employees. These practices manifest in several ways. Misuse of temporary levels. Employees engaged for work that is essential, recurring, and integral of the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. Such misclassification deprives workers of the dignity, security, and benefits that regular employees are entitled to, despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or notice, as seen in the present case. The practice undermines the principles of natural justice and subjects workers to a state of constant insecurity, regardless of the quality or duration of their service. Lack of career progression. Temporary employees often find themselves excluded from opportunities for skill development, promotions, or incremental pay raises, they remain stagnant in the roles, creating a systemic disparity between them and their regular counterparts, despite their contributions being equally significant. Using outsourcing as a shield, institutions increasingly resort to outsourcing roles performed by temporary employees, effectively replacing one set of exploited workers with another. This practice not only perpetuates exploitation but also demonstrates a deliberate effort to bypass the obligation to offer regular employment, denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave, even when their tenure spans decades. This lack of social security subjects them and their families to undue hardship, especially in cases of illness, retirement, or unforeseen circumstances. While the judgment in Umadevi Supra sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who are engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Umadevi Supra to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable services over decades. In light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employee morale. By ensuring fair employment practices.
All right. You pass over the judgment, we'll refer it to you. So that's it. What have you got to add? Don't repeat anything.
No, if I need to distinguish the facts, only that.
He was originally appointed as pipeline engineer. Then again, he was engaged contractually as
For a
mechanical
particular
engineer.
project.
Yes.
For a particular project.
That's right.
Here in this case that my friend is referring to, were ad hoc employees who were asked to perform a perennial nature of job. And therefore, they sought for regularization in the tribunal. And therein, the moment the tribunal dismissed their application for regularization, the authorities proceeded to abruptly terminate their employments. And that led to these litigations, wherein this honorable court had passed this order. But here the facts can be distinguishable. Here it was for a particular contract, and the dates of the contract were already there in the agreement, to which he has signed. So therefore,
This is not reported judgment.
Reported judgment, Lord.
Reported.
Yes.
What is the citation?
Citation right now I'm not having.
Okay, we'll find out.
Lordship, and one more point, Lordship.
Wait, let them finish. You want to reply anything? That's all. Anything
Yes,
else?
yes, Lordship.
Yes, Mrs. Saike. If you argue too much, then it may go against you also.
We have been qualified. As for the appointment method we applied, and we were selected by the competent interview board. And then after selection, my lord, I have filed the affidavit, we were appointed. And since then, we are working. And my friend's client did not appear before the selection test because he was 48 years old. So when he was awarded, he did not apply him. So since he did not apply and he was not qualified and work on only contractual basis for a particular period, my lord, while he was working on a contractual basis, he did not apply.
that I should be allowed to participate in the interview board. So Lordship, our appointment was regular, and now we are working regularly.
All right.
This is my humble submission, Your Lordship.
Lordship, the job.
And the selected candidates, my lord, they did not, they have no locus standi, that they could not point out that anything wrong or any that we are not eligible, that we have not been regularly selected, that we have not been regularly appointed, my lord. I have filed the affidavit, my lord. And order of appointment, my lord, in my affidavit at page 7, my lord.
Lordship.
Yes.
Lordship. If we see page number 49, that is the post-qualification relevant experience, Lordship. Knowledge of pump station pumping operations, which includes custody transfer of tanks, maintenance aspects of IC engine, centrifugal and reciprocating pumps, knowledge of pipeline pigging operation, knowledge of safety standards as per the latest oil industry safety directorate norms followed in pipeline operations, knowledge of starting of pump operation in coordination with dispatch control room, knowledge of safe starting of pump engines along with auxiliaries from pumping operation and stopping at the same during pump shutdown. So at the time of this advertisement, Lordship, issuance of this advertisement, he was the petitioner was doing exactly what was required, because this advertisement is for permanent post, Lordship. And if Lordship comes to page number 44.
Correct. Yes.
If Lordship comes to page number 44, Lordship.
Page number 44.
44. So this is the custody transfer of tank. You will be performing the following jobs during your assignment on contract in Tengaghat Pump Station. Custody transfer of tank handover and taken over with ITF Tengaghat. Continuous monitoring of operation and maintenance of pumping operation. Pig launching at Tengaghat Pump Station. So exactly the same. So this was his experience. This was his experience, Lordship. So this was what he was doing. So his work was of perennial nature, Lordship. His work was of perennial nature. And page number 46, Lordship, he was appointed as competent person by the Tengaghat Pump Station, Oil India Limited, for pipeline oil mine. He was appointed as competent person. And page number 47, if Lordship comes to para number 1, 2, 3, 4, just below that that table. Since the
Tengaghat, you have to conclude now.
Yes.
You are good.
Yes. Since the Tengaghat Pump Station operates in 3-shift duty and also considering its distance from the residential area, Duliajan, and in absence of placement of permanent engineers at Tengaghat Pump Station, the services of the hired contract engineers are critical and essential for operation and maintenance of the pump station operation.
All right.
So the performance and services of these mechanical engineers have been found satisfactory. So this is a departmental letter whereby the department itself was seeking extension of their contract, but due to pendency of the writ petition, their contract was not extended, Lordship. So this will be my submission.
All right. I heard Mr. B. Acharya, learned counsel, appearing for the writ petitioner. Also heard Mr. A. Sharma, learned standing counsel, Oil India Limited, appearing for the respondent numbers 1 to 8. Mr. R.C. Saikya, learned senior counsel, assisted by, yes, who is assisting? S. Bora, has appeared on behalf of the private respondent numbers 9 to 12. Anybody for 13? CIC? None has appeared for the respondent number 13. Full stop. The writ petitioner herein is aggrieved due to non-consideration of his prayer for regularization of service under the Oil India Limited, even after completing 10 years of contractual service. Full stop. The facts of the case, in a nutshell, are that on 26 January 2007, the Oil India Limited, bracket of OIL Digo, bracket close, Duliajan, had issued an advertisement notice for engaging an experienced mechanical engineer on contract basis for a purely temporary requirement for, within quotes, pipeline expansion project, unquote, from Numaligarh to Siliguri, bracket PEP-NSPL, full stop. The advertisement notice itself had mentioned that the contract would be valid for a period of 1 year or till completion of the project, full stop. In response to the advertisement notice dated 26/1/2007, the writ petitioner, being qualified to be engaged as a mechanical engineer, had submitted his application, full stop. After considering the application submitted by the petitioner, he was engaged on contract basis as senior pipeline engineer, as mechanical engineer, wide appointment order dated 23/4/2007, initially for a period of 1 year, full stop. For a period of 1 year, full stop. Accordingly, a contract agreement was signed by and between the petitioner and the OIL, full stop. After the expiry of the contractual period of 1 year, fresh contract agreements were entered by and between the petitioner and OIL for various periods, ranging from various periods of engagement, ranging from 6 months to 1 year, full stop. As such, as the scope of the work and period of its completion was expanded, the service of the petitioner also got extended by virtue of separate contractual agreement containing specific terms and conditions of contract, full stop. Eventually, the contractual service of the petitioner came to an end on 18/11/2017, full stop. Thereafter, the OIL had issued an advertisement notice dated What is the advertisement notice? Page 48? Dated?
Date is 12/7/2007.
12/7/2017. Where does one find the date? Mr. Sharma, where is the date available?
The date otherwise is in the available in the prayer portion. The prayer he has recorded that. Advertisement number along with the date, 12/7/2017.
So you issue advertisement without a date.
Yeah. Probably.
Fantastic. Really, really commendable.
Right hand side top portion, the small letters, the advertisement number is there. I think the date was probably also there. Page 48, top portion, small letters.
Issued an advertisement which was published on 12/7/2017, inviting applications for filling up various posts in grade capital C, within quotes capital C, which included as many as 4 posts of senior pipeline engineer. Full stop. The advertisement notice had laid down the educational qualification, experience, and other eligibility condition for participating in the recruitment process. Full stop. Since the petitioner was overaged, hence he could not submit his candidature in response to the advertisement dated 12/7/2017. কিমান আছিলে? 12/2017. Agree, full stop. By that time, the petitioner's contractual engagement also came to an end. Stop. Aggrieved thereby, the petitioner had approached this court by filing WPC number 4642 of 2017, challenging the advertisement notice dated 12/7/2017, with a further prayer to regularize his service in respect of a permanent post. Full stop. Since no interim order was granted by this court, the recruitment process had proceeded and the same was eventually concluded. Full stop. As such, WPC number 4642 public 2017 had become, the same was concluded. Not only that, the selected candidates, namely the private respondents herein, were also appointed. As such, WPC number 4642 oblique 2017 became infructuous for all practical purposes. As such, on a prayer made by the petitioner by filing IA bracket C bracket close 1476 oblique 2020, this court had passed order dated 9/10/2020 permitting the petitioner to withdraw the said writ petition, i.e. WPC number 4642 of 2017. Full stop. In the present writ petition, the petitioner has once again made a prayer to interfere with the advertisement notice dated 12/7/2017 and also to issue a direction upon the respondents to regularize his services. Full stop. The petitioner has also prayed for issuance of a direction to the Central Information Commission to initiate disciplinary action against the respondent number 6 on account of his alleged failure to follow the mandate of the Right to Information Act, 2005, whereby the respondent number 6 had allegedly furnished false information to the petitioner with malafide intent. Full stop. The writ petition filed by the petition has been contested by the Oil India authorities as well as the private respondents by filing separate counter affidavits. The stand of the authorities, reduced to its essence, is that the petitioner, being a contractual appointee whose continuance was purely on the basis of separate contractual agreement, there cannot be any right claimed by the petitioner for regularization of his service against a regular vacancy. First up. Next para. Mr. B. Acharya, learned counsel for the petitioner, has argued that having rendered long and continuous service for more than 10 years and the nature of work rendered by the petitioner being of perennial nature, it was not open for the authorities dispense with the service of the petitioner in such manner. Full stop. Mr. Acharya submits that keeping in mind the experience and the long years of service rendered by the petitioner, the oil authorities were duty bound to permanently absorb the petitioner by regularizing his service, hence this writ petition. In order to buttress his above argument, Mr. Acharya has placed heavy reliance on a decision of the Supreme Court rendered in the case of Jaggo, JAGGO versus Union of India and others, reported into Pale available. Full stop. Mr. A. Sharma, counsel for the oil, submits that the petitioner does not have any enforceable right, and considering the fact that the selected candidates on being appointed are continuing in service for more than 3 years, at this stage, there cannot be any question of interfering with their orders of appointment. Full stop.
5 years.
Huh?
5 years.
5 years. 5 years. Mr. R.C. Sekhar, learned senior counsel for the private respondents, has also made similar submission by contending that no case has been made out by the petitioner so as to interfere with the appointment of his client. I have considered the arguments advanced at the bar and have also gone through the materials available on record. At the outset, it would be pertinent to mention herein that there is no dispute about the fact that the petitioner was originally engaged as a contractual employee for a period of 1 year based on an agreement entered by and between the petitioner and the OIL, which had clearly mentioned that the engagement would be for a period of 1 year. Thereafter, the petitioner continued in office. The petitioner was engaged from time to time on several occasions, albeit on signing of separate contractual agreements laying down the period of engagement. On each occasion, the engagement of the petitioner was for a period of 6 months, while on some occasions it was up to 1 year. However, there was a break between such engagements of the petitioner, which was ranging between 2 to 5 days. Is it 2 to 5 days?
In fact, hold on, sir.
Huh?
Page 80 of the affidavit, you have given the entire list of engagements. There has been gaps of 15 days also, Lord.
With gaps of
16 days also, page 81.
2 to 16 days on odd occasions.
Yes, Lord.
In other words, it is not a fact that the petitioner has been in continuous engagement under the Oil India Limited since his initial engagement till 18/11/2017. Full stop. Be that as it may, since the writ petitioner was on contractual employment under the oil and had signed a contract agreement containing specific terms and conditions of service, his service conditions would be governed strictly by the terms of the contract. Full stop. Under such circumstances, the question of absolving the petitioner against a regular vacancy without his participation in a recruitment process cannot arise in the eyes of law. Full stop. In other words, permitting a contractual appointee to be absorbed against a regular vacancy without undergoing a regular selection stroke recruitment process would amount to backdoor entry in service, and hence the same, in the opinion of this court, would not be permissible. Full stop. Unfortunately, when the advertisement notice dated 12/7/2017 was issued, the petitioner was overaged and he could not take part in the recruitment process. First up. Situated thus, this court is of the opinion that although the sympathies of this court would go with the petitioner, yet the facts of the case would not give rise to an enforceable right of the petitioner to be regularized in service without facing a regular recruitment stroke selection process. Full stop. Next paragraph. In the case of Jaggo Supra, the writ petitioners who were engaged as safaiwalas on ad hoc basis were allowed to continue for long years. Full stop. Those petitioners had claimed regularization in service by urging that due to the continuous long years of service and the nature of work executed by them, they were entitled to be regularized in service. Full stop. However, instead of accepting their prayer, the authorities, being emboldened by a decision of the tribunal rejecting their prayer, had in fact terminated the service of the applicants, stroke petitioners therein. Full stop. It was in such facts situation the Honorable Supreme Court had observed that, had directed that had observed that workers engaged on temporary basis for extended periods, especially when their roles are integral to the organization's functioning, would have a right to be considered for regularization. Full stop. Consequently, a direction was issued to the authorities to take back the petitioners stroke applicants by setting aside the orders of termination of their services. Full stop. After going through the aforesaid decision, this court is the opinion that the judgment rendered in the case of Jaggu bracket Supra is clearly distinguishable on facts. Full stop. That was not a case where the initial engagement of the employees were on contract basis, based on contract basis governed by specific terms and conditions of contract. Under the circumstances, this court is the opinion that there is no scope to grant any relief to the petitioner in the facts of the present case. Consequently, the writ petition is held to be devoid of any merit and the same is accordingly dismissed.
Obliged.
Can't help it. Your client, if you are still in service, we would have thought something.
Yes.
Can't help it. Yes.
Obliged, Lordship.
Lordship. In item number 13, our counsel's name has not been shown, Lordship. We are for respondent number 228. Only the accommodation for today will be required, Lordship.
Yes, Mr. Sarabati will be next.
Mr. Sinha's name may be shown
List
in
the
the
matter
first.
for hearing again after 2 weeks by name, by showing the name of learned counsel for the respondent numbers 2 to
8.
8 in the cause list.
Obliged.
Obliged.
Mr. A. Chaudhary, learned counsel for the petitioner is present.
It pleases your lordship.
Yes.
Lordship, herein the petitioner is working in Asalsa. Their appointment, lordship, was as per the government notification, and then they were given the same salary as per the officials at Secretariat and also High Court. But later on, by the 7th Pay Commission, their case was not recommended to the
Who is for the respondent?
Mr. Barpujari. I'm sorry, Lordship, I started without looking. Mr. Barpujari appears.
So you're seeking parity of pay with the High
Yes.
Court employees.
High Court and as well as Secretariat, because the starting salary was same. Later on, in the 6th Pay Commission, it was same. In the 7th Pay Commission, this employees, she and 5 others are there. Only 6 people. Their year was not mentioned, and so their salary was not increased. Now,
Now, they filed affidavit, finance
yes,
department?
please.
What is the stand?
They stand, in fact, in our petition, in our reply to the writ petition also, their stand is that they cannot do because we have to approach the pay commission but that is not the system. It is the government who recommends. Let Mr. Borpujari come, Lordship.
Lordship, I am also representing respondent number 1, 2, 3, and 5, Lordship. Lordship, we have our instruction, but inadvertently, Lordship, this could not be, affidavit could not be filed. So if your Lordship kindly allow me at least 10 days time, in the meantime, I shall file the affidavit, Lordship.
Okay, Lordship. No
Because
issue.
it's a
If he supports me, no, no issue.
There you are. Do you know what has happened in this case?
Yes.
You know what has happened? She has prayed for time to file affidavit. So we'll adjourn it. Heard Ms. Ida Majumdar, learned counsel for the petitioners. Also heard Ms. N. Bhattacharjee, learned additional senior government advocate appearing for the respondent numbers.
1, 2, 3, and 5, Lordship.
1, 2, 3, and 5 who submits that she has received instructions and therefore be granted 3 weeks time to place the same on record in the form of affidavit. Mr. R. Bopujari, learned standing counsel, Finance Department, Assam, is also present. On the request of Ms. Bhattacharjee, this matter is directed to be listed again in the first week of May 2025. In the meantime, affidavit on behalf of the official respondents be filed by serving advance copy upon the petitioner's counsel.
I can file a reply, Lordship.
Yes.
File your reply, Lordship.
Wait, please, Your Lordship. On the last date, Lordship was pleased to direct me to submit a written note, my lord. I submitted today, my lord.
And circulate it. I got it today.
Oh.
Advance.
You circulated today. I thought I'll go through the note and then.
My lord, my lord. My senior got it today morning, my lord.
What is the issue here?
My lord, I was a grade C employee of Oil India Limited, my lord. The span for promotion, that's a period of promotion, is 5 years or 6 years. That is based on selectivity ratio. All the grade C employees, they get promoted to grade B. But 70% of them who are higher in the merit, they get promoted on completion of 5 years, and the remaining 30% on completion of 6 years. Well, there is a concession given to SC/ST employees. I am an unreserved category employee. The concession is that those who are in the zone of consideration and who are senior in skill, provided they are not deemed unfit for promotion, they have to be included in the select list for promotion. But in this case, the concession, my lord, is based on pay scales. The pay scale identified, my lord, for central public sector enterprises is, my lord, is grade E5. That grade E5, my lord, is not based on any hierarchy or the number of scales which they have, but the particular scale. That pay scale is, my lord, identified as grades, as the pay scale given to grade C. So therefore, there cannot be any concession given for promotions to grade D. So therefore, the application of this concession in promotions to grade D, my lord, in my humble submission, was incorrect. They could not have been. So, my lord, I have not challenged the promotion given to the private respondents. But, my lord, my contention, my lord, is that I ought to have been promoted in on completion of 5 years in 2021, with effect from 1st of January 2021. I have been given effect, the promotion, my lord, has been given effect from 1st of January 2022. But I am entitled to be promoted with effect from 2021. My lord,
So you are basically claiming seniority.
my lord, seniority,
Effect of the
promotion, my lord, the benefit of that, because I'll be retiring on 30th of April this year, my lord. So other than that, my lord, I would not upset the seniority positions. There's another aspect. My lord.
Nayar, please tell us one thing. Supposing your prayer is accepted, assuming, then the result is you get effect of your promotion antedates.
Yes.
The actual date.
Mine.
That will be on the ground that somebody's promotion was not correct.
Mine.
Somebody has been promoted in a manner which is not in accordance with the rules. That declaration has to be given.
That declaration, of course, my lord, but I have not made that challenge.
No, then that's the reason I wanted to see this.
My lord.
Without that challenge, how the declaration can be
My
made?
lord, because in any case, my lord, they are entitled to the promotion on completion of 6 years. All the employees in grade C, it is not based on any number of vacancies, my lord. All employees, they get promoted. My lord, there was a second leg of my argument, my lord. That, my lord, is that if assuming this concession can be applied, what the Oil India did, my lord, was they removed persons from that 70% list and they accommodated the SC/ST persons. But, my lord, they realizing that this was faulty on their part, my lord, they corrected it by issuing a clarification in the subsequent policy saying that the concession will be applied in addition to the selectivity ratio. So therefore, my lord, there is no change in the concession, in the presidential directive in respect of the concession or in the pay scale. The present, my lord,
yes,
the present implementation of the policy is, my lord, no one is removed. The persons in the SC and ST categories, they are also given the promotion. That is the reason why I have not challenged it, my lord.
So what is the urgency in this case?
I'm
If you
retiring
succeed, you will get money, that's all.
My lord.
Then
My lord, up to lordships, my lord.
what is the urgency? Mister, do you have any urgency?
No, my lord.
Sometimes one cannot figure out who has the urgency, who doesn't have.
We don't have the urgency, my lord. Had there been an interim order, perhaps, my lord, there would have been urgency, and he is retiring, my lord. Retiring will not affect the ultimate result of the case.
If my lord could accommodate before my retirement, my lord.
We'll hear it on 3rd April then.
My
3rd
my
April.
my.
Mr. Nayar, counsel for the petitioner submits that he has already submitted his written note of argument, but the copy of the same has been furnished to the learned counsel for the respondent today only. In view of the above and on the request, Mr. M.K. Chaudhary, learned senior counsel appearing for the OIL, submits that a copy of the written argument has been submitted to furnished to him only today. In view of the above and on the request of learned counsel for both the sides, We can have it on 3rd or 10th, whichever.
Third, my lord, would be, because if I get any benefit, my lord, for my retirement.
3rd April.
Deeply obliged.
Obliged.
Yes.
May it please your lordship. My lord, in item number 19, I am appearing where I have, my lord, challenged my denial for further consideration to the post of junior engineering assistant. And my lord, the department has also filed an affidavit admitting that I was erroneously denied. So, my lord, my petition deserves to be allowed, my lord, and my candidacy may be further considered, madam.
Department means this is IOC.
IOC.
Who is appearing for?
I appear for it. There are two sets of writ petitions. Let me to clarify the position. This pertains to selection process. So once the selection process was over, two persons, that is Mr. Patwari's client and another person, they lodged a complaint saying that we could not have been ousted based on the marks that we got. We were entitled to a particular relaxation which was not given to us. That is how we were erroneously ousted. Once we looked into the complaint, we found that there is truth in the allegations. And once we went into that, we found that these two persons had actually got much higher marks than the person who was actually appointed. So based on those internal inquiries, we conducted an internal investigation. And those persons who were appointed, and while undertaking that exercise of going through the complaint, we found that in addition to these two, there were 5 other candidates in respect of whom there were anomalies in the selection process. So since they were on probation, we thought that we will not go further into the issue. And your lordship is aware of the law pertaining to probationers. So we issued orders of termination simpliciter. So that set of persons who were terminated are the other batch of writ petitions. So there are basically 2 sets of writ petitions before your lordship. One is Mr. Patwari and his client, and another person who claimed initially lodged a complaint and thereafter approached this honorable court saying that we were illegally ousted. Once that was set in motion, we found that there is correctness in the allegations, and the other writ petitions are an outcome of that. So this will require, I don't know, subject to what my friend Mr. Dekai appears for the other set, terminated persons.
Yeah, I'm appearing for the terminated employees. Lord, the genesis, of course, was one of the petitioners submitting a representation before the vigilance, my lord. And they say that based on that complaint, my lord, they embarked upon an inquiry opening up the entire selection process 1 year after the appointment, my lord. And they not just terminated the person who had availed that, who had occupied that seat by way of age relaxation, but they carried out a slew of terminations. Now, those terminations, in the affidavit, the IOCL claims that it's a termination simpliciter, and it's basically a non-confirmation of the probation. But if your lordship sees the order itself, if your lordship has the first writ petition, which is 1069, page 40, just for a moment, Lord.
Okay, you just spell out what it is.
My lord, the order of termination reads as that acting upon a complaint, letter dated so-and-so, received by vigilance, an internal inquiry was conducted with respect to the instant recruitment process, and on the basis of the internal inquiry and recommendation of the CVC Government of India, it has been revealed that you have been erroneously selected, appointed to the said post. Indian Oil Corporation is a public sector undertaking in a company registered under the Indian Companies Act. The company is state for the purposes of Article 12 of the Constitution. It is governed by statutory rules and regulations and has the mandate of law to follow the rules and regulations in manner of public employment. Since you have been erroneously selected, appointed for the post in deviation of the applicable recruitment rules, your appointment as so-and-so by the offer of employment number so-and-so stands withdrawn. Now, first of all, my lord,
just a minute, you are appearing in which writ petitions?
I'm appearing in 18,
yes,
21 to 24.
And how many petitioners are involved here?
5.
Achha, each case one.
Six.
Each case one petitioner.
Each case one petitioner. No, no, our case is very
Just a
different.
minute, just a minute. Mr. Patwari, in item 19 and only 19. You are 20. So you both are sailing in the same ship. You will actually be the beneficiary of this process. And how many petitioners? One each. So now 6 probationers
My lord.
have been terminated or discharged.
Yes,
The ground that they are showing is an erroneous calculation.
right.
That means 6 others will come in,
6 others will come.
out of which 2 are before us. Who are the other 4?
My lord, that
Who are the
depends.
other 4?
My lord, the selection
That will
list has
depend on the
already-
selection because
They'll-
there were several candidates who probably got ousted wrongly, erroneously. So we'll have to redo that exercise from that stage. After the written examination, there are further stages. So we'll have to redo the exercise from the stage of just immediately after the written examination.
Just to clarify.
Or maybe a fresh advertisement altogether. So that is a call we have not taken.
Just to clarify, my lord, item numbers 19 and 20, my lord, they said that we were not given age relaxation based pursuant to which the petitioner number, a petitioner in item number 18 was erroneously appointed, my lord. They say, had we got the relaxation.
No, Mr. Dekar,
My
see, subject to what you say,
my lord.
let us look at the larger issue which is involved here. What is the legal issue here?
My lord.
Who gets in, who gets out, that will come to it later.
My lord.
Your clients were issued appointment orders and their appointments were on a probation.
Right.
For how many years? 1 year or
1
2
year,
years?
1
1
year.
year. During this probation period, some developments took place. Some people lodged complaint, etc. The Oil India, the IOC authorities have looked into the matter and found that there were some anomalies. And they say that being a public sector undertaking, we have to rectify whatever has happened. They found that your clients were wrongfully given the appointment orders. In terms of merit, they did not qualify to get it. Instead, there were other candidates who were wrongfully denied the orders of appointment. The grounds could be different. For X, the ground could be some, Y, the ground could be same.
True.
And 2 of them are in item 19 and 20
Right.
before us.
Right.
It is in these circumstances to rectify the anomaly which is crept in, they will have to make way for these candidates to be absorbed. Correct.
Right.
So they discharge your clients. Now, a probationer can be discharged on any ground.
True.
But the point here is, this discharge of the probationer is not because of any deficiency in your performance.
Right.
It's because of a mistake committed by Oil India. The mistake was also of Oil India's or IOC's, and the attempt to rectify it also is by them. So either ways, it is a creation of the IOC, which now they are trying to rectify. Only thing is, earlier it was a wrong or something wrong which was committed, now they want to rectify. Ordinarily, there cannot be any quarrel with that argument. But the point is, one legal issue would be that once you are appointed, unless there is any complicity on your part, has a right accrued in your favor. That right would be very minimal because probationers can be discharged. But only question here is, what are the parameters of exercising that right to discharge probationers? That we'll have to see.
Right.
The other point is, supposing you contest it, in order to succeed, you have to show a better claim against the persons who, according to the IOC, are the deserving persons. You know only 2 of them. The remaining 4 you don't know as of now. They also don't know because the picture is not clear.
Right.
Until an exercise, the whole exercise is done, it is not clear even whether they will be in or they will be out. Right.
Right.
So, without knowing that picture, the legal issues are in a completely amorphous form. it'll be difficult for this court to take a view. It could go this way, it could go that way. Who are the people who are actually eligible and why? That is information the court will have to have. Before that, neither can their claims be given, because tomorrow, unless they do the whole exercise, how do they not know that 6 people could be better than them? Is that correct, Mr.
In fact,
Chairman?
Mr. Patwari's client and Mr. Deka's client, RM Deka's client, they are contesting for the same post. So even out of, assuming they are the ones who come into the consideration, only one out of those 2 will get. So the thing is very fluid.
That's true, my lord. My lord, here I'm mindful of the rights of a probationer, my lord. Here my limited ground is this termination was served out of the blue. I was not even put to notice, my lord.
No, that's not required. That's not required.
No, my lord, because going by the tenor of the order, first of all, my lord, they have conducted an internal investigation behind my back. My lord. Secondly, my lord, the
Investigation is not pertaining to you. Investigation is pertaining to entire process.
My lord, no, they've selectively done it for 5, and they've said for someone they've said that your OMR sheet marks are manipulated. For someone they're saying that your experience certificate is not right. No, my lord, the question of why did they even embark on this inquiry when the original complaint was only regarding age relaxation? Now they sought to give it a color as if there has been large-scale manipulation in the recruitment process after 1 year of the appointment. Now, my lord, going by the order, although it may seem innocuous, my lord, it has a stigma attached to me. Because ultimately, if I go with that termination before a prospective employer, my lord, the future employer, he'll get the impression that here's a candidate who is manipulated.
Agreed.
So only for that limited purpose, because they did not even serve me a notice. The termination order was slapped on
If
me.
there's a stigma, then if it is stigmatic,
So therefore, my lord, first, I would say if I've understood the law correctly, my lord, I'd say it ticks all the boxes, my lord. First of all, there's an inquiry behind my back. I'm not put to notice. What is the scope of the inquiry? The scope of the inquiry is to see whether there has been manipulation or not.
yeah, I mentioned it.
Right.
That discharging a probationer without any further
Right.
communication is possible if it is pertinent to his performance during
Exactly,
the
my lord. Had they said that we do not want see you fit
we are
to
not
be
happy with
confirmed.
you. Go.
Right.
Then it's another thing.
Right.
But here it has nothing to do with the performance.
Right. Exactly.
It has got
That's
to do with
precisely
the
my
process through which you came, and there is, according to what he says, there is some allegation that
No
That
allegation against them. Let me give the facts. In this same advertisement, 44 posts were advertised.
what post of what? What
Various, they are junior
engineering
engineer
assistants
in different categories.
All right.
So 44 posts were advertised. So these 2 persons, Mr. RM Deka's client and Mr. Patwari's client, they lodged a complaint, and they also simultaneously approached this honorable court, preferring these 2 writ petitions, items 18 and 19. Once this happened, our internal investigation was set into motion, and we looked into this entire selection process. Once we found that these 2, in respect of these 2 persons, there has been a mistake, and these are very innocuous mistakes.
Quite natural, yes.
Once the entire selection process was looked into, we found that these are not the only 2 persons who were wrongfully ousted. There were 4 or 5 others. Out of these 44, we have terminated only 6, in respect of whom we found that there were some errors. And those errors, we have not attributed anything to the probationers. It was innocuous mistakes, errors of calculations, or maybe some marks wrongly added here, some marks wrongly not given there. All those things, once it came to light, as a public sector undertaking, how do we carry on? Because Article 14 and 16 of the others would get violated. So we found that in respect of these 6, there are very clear anomalies. Even the investigation does not attribute any fault on the appointees. It says that these are errors.
No, but he's saying there is stigmatic.
No, absolutely not. No.
Mr. Deka?
My lord, I'll just read out for one writ petitioner, what have they said, my lord? They've said, this is item number
Where
20.
is the stigmatic order? Sure.
My lord, we'll have item 25, my lord, because there's one slew of termination, my lord, different ground.
Can you give the case number?
My lord, this is 1077 of 23.
1077 of 2000.
1077
Angshuman.
These names are so deceptive, no? Petitioner's name. One case, this name, another case, that name.
On the page 46.
Yes.
Page 46 and extra 10, my lord. Paragraph 2 onwards. That acting upon the complaint letters dated so and so received by vigilance, an internal inquiry was conducted with respect to the instant recruitment process, and on the basis of the internal inquiry and recommendation of the CVC, Government of India, it has been revealed that you have been erroneously selected, appointed to the said post. Para 3. That it has been revealed that you have entered in SPPT without experience certificate, and the document was submitted after cutoff date. Further, you have submitted 2 experience certificates with different designations from the same employer, which are contradictory and ambiguous. Indian Oil Corporation is a public sector undertaking in a company registered under the Indian Companies Act. The company is a state for the purpose of Article 12. It is governed by statutory rules and regulation and has the mandate of law to follow. So, my lord, on the face of it, it may not seem too state, but here, my lord, there's an internal inquiry, there's an allegation, there's a vigilance inquiry. Then it is alleged that I submitted certificates after cutoff date, the 2 contradictory certificates. And aren't these somehow pointing the needle of suspicion or allegation towards me, my lord?
No, that you are correct. This paragraph 3 was totally unnecessary.
Yes, my lord.
Somebody did it without knowing.
Then there is other
But
where
the point is, this is not stigmatic. And even if it is, this is a useless formality, because if they've said that otherwise you do not see, the point is, if your entry into the system is genuinely based on an erroneous calculation, that will not be sustained by the court of law.
Could I?
So what difference will it make? 2-3 months you hang around here. That's all. You are not. You will have to be able to dispel this.
Right.
And you are not in a position to do that today.
The point is, Manoj, if you're finding fault with my experience certificate, should I not be at least put to notice?
Forget the experience certificate.
Right.
The ultimate thing is they are saying you have been erroneously selected. You have not scored the amount of mark which puts you in the merit position above the other candidates. That's the sum and substance of their allegation. So leaving aside everything else,
right,
assuming that the court for once holds that it is stigmatic,
right,
they'll give you a notice and then terminate it. That's all.
At least that exercise, Manoj.
Or
At
you
least
can
that exercise.
what will happen?
Of putting me to notice to explain my position, Manoj, how these
Or
experiences.
we can say that this since it is without holding an inquiry, these observations will be null and void. Same thing.
It is after holding an inquiry. Manoj.
No, Mr. Dekar, you have to ultimately see the court proceedings can't be just a useless formality.
Right.
If they are saying that there was a mistake in appointing your clients, because people scoring higher marks or more eligible as per this merit position have been ignored, and we are trying to rectify that. Fundamentally, what is wrong with that argument? That is a correct argument. They are owning up their responsibilities, and now they are trying to rectify it. Unless you show that there is something wrong with it, let's say the Malafide exercise.
I have said that in my writ petition because my lord will consider the entire scenario, my lord. What prompted them to go into?
He's saying it.
My lord, now, if your lordship sees that is affidavit, you know? My lord, if your lordship sees the affidavit filed by the
No, what prompted them? He said one application led to a deeper look.
And what did that application basically say, my lord?
Whatever it says, that application was the trigger. Something was triggered, and after that, they're not entitled to look into their own doings or
My
misdoings.
lord, this was after I had rendered more than 1 year of service.
But he was still in probation.
I was not confirmed, my lord. I'll agree to that.
And the meaning of probation is that you may be discharged without notice. That's what is mentioned.
That is there in the appointment also, my lord. So therefore, I want to
So what I'm asking you, what is the fundamental uncuttable case that you will come up with here? You little here, little there, little argument. That doesn't help, because their fundamental ground is that we made a mistake. We have made a mistake in offering appointment orders to these 6 petitioners who were actually not qualified. There were other candidates who scored higher marks than that.
Right.
We want to now rectify the mistake. And the courts will say, sorry, you cannot rectify.
That's fine, my lord. Again, coming back to notice, my lord, my question is, first of all, if you have an inquiry, you better have me on board.
Secondly, though this order, though in the affidavit, they've said that we did not want to stigmatize, therefore we did not go ahead with the order. The order speaks for itself that a full-fledged inquiry was done.
Difficult. Very.
I try to satisfy regarding that stigma part also, because there are my entry very there's in fact a judgment by the Supreme Court where it said similar cases.
Mr. Deka, in other words, unless you can satisfy the court that no, it is your clients who has scored higher mark.
Well, I'm saying because
tell them to be ready.
Malord, I'm saying my experience certificates are genuine, insofar as Anshuman is concerned.
All right.
Malord, insofar as others are concerned, I'm saying my OMR calculations were right. You could not have possibly gone wrong because there is an OMR scanner where the marks are calculated on that basis. So a human calculation to see whether the marks feeded to the machine is right or not, that too after 10 years on the basis of a complaint that was concerning only age relaxation, was totally uncalled for. And all said and done, again coming back to that, at least I could have been put to notice, Malord. If they initiate an inquiry, putting me to notice,
What would have happened if they had put you to notice?
I would have, insofar as Anshuman is concerned, I would have shown that these certificates are in parity with your eligibility requirement. Insofar as others are concerned, I would have.
But you still, nonetheless, you still have the stumbling
And
block.
one very vital aspect I'll just like to point out, Malord. Rahul Das's case, Malord. Rahul Das's case, Malord, they said that as per the advertisement, we are entitled to a cumulative age relaxation. One on account of me being OBC, and second on account of me having undergone some training. Malord. In that writ petition, Malord, that's how I allege malafide, Malord. The same deponent, first of all, files an affidavit in opposition saying that no, you are not entitled to a cumulative age relaxation, Malord. After that, Malord, after the terminations are over, Malord, he files a totally contradictory affidavit and says, no, we were actually wrong in our first affidavit. You are entitled to age relaxation. And all of this was done, Malord, at a time when 2 writ petitions were pending, Malord. The issue of age relaxation, I believe, was not a very simple issue, Malord. It's an arguable point, Malord. While the writ petitions were pending, Malord, they decided that no, we will not even wait for the outcome of the case to see whether these 2 petitioners were entitled to age relaxation or not. And although they had submitted an affidavit, they made a volte-face.
All right. So this is which category? All these 6 posts are which category?
There are different categories.
They're known as the junior engineer.
All are in the rank and cadre of junior engineer. The departments are different. That is reflected in.
I'll just indicate. PNU.
No, but total posts are 44.
Total posts altogether advertised were 44.
Then Mr. Chaudhary, why don't you do this exercise and see what is the final merit list according to you and give it to us in a seal cover. We'll see who is in, who is out.
So for that, we'll have to call them back. Unless, because that might end up being a futile exercise. If the issue goes against us, that entire exercise would be a futile exercise. That is why we have kept everything on hold, waiting for an outcome of this.
Call them means whom? Call whom?
Because there might be many others whom we might have to call back. Or alternatively, now since this advertisement is very old, there is also a contemplation that we will, for these 6 posts, will issue a fresh advertisement. So that
is okay. You can issue advertisement, but the point is, this 6 persons' job is at stake. So first we have to settle this.
Yes, that is why we have waited. Showing due deference to these litigations, we have kept everything on hold, waiting for the outcome of these cases. After that, if we have, assuming worst case scenario, your lordship allows the writ petitions, then we won't have to undertake any exercise at all. If these writ petitions are dismissed, then we will be left with 2 options, either to restart it from a particular stage or to go issue fresh advertisement.
So all right, then the only issue is, insofar as these 6 petitioners are concerned,
whether it is stigmatic or not.
Stigmatic or not.
And even the certificate issue pertains to only one. With respect to others, it is wrong calculation of marks, wrong ouster of candidates above him. So there is no question of stigma at all. Only the one which my friend read out regarding that certificate issue. There, if at all it can be called he submitted a fresh certificate, which is after the date of last date. So that was the ground, and in both these certificates, there were two different designations mentioned by the same employer. So therefore, we said that your candidature could not have been accepted. So how can we are not attributing any stigma to him? We are saying that this was a mistake on our part in accepting this certificate. So therefore, my lord,
For the others, my lord, they use the categoric word, there's been a manipulation, my lord. My lord, going by the
Not
dictionary
attributable.
meaning, my lord, manipulation would be some.
Manipulation by whom they didn't say.
They did not, they may not have
Could be
said.
by their
But
officials
your
also.
lordship will imagine a scenario when I take this to my future employer, my lord. It'll come across as because
That, if that is your argument, then we can.
your lordship
take
may
care of
expunge that word, man.
no, my lord, that is to see whether it was motive
One
or
more
foundation.
opportunity. You come up with a fundamentally uncuttable argument, otherwise you are in trouble, your clients. It's possible that you can come up, but the argument should be such that the court has no option but to accept it.
I'll try to, my lord.
You have to think beyond.
Right.
Otherwise, this argument, what you are now submitting, I can dictate the judgment in 5 minutes. Look up the law on these probationers, stigmatics. See, these are very often used expression. Probationers can be discharged. It's actually a discharge. Where the motive and foundation, these are all there, you know.
This ultimately, my lord, that is what I was trying to, my lord, if we go.
But every case, every situation, every facts are of different dimensions. You see, the projection, the throw is very different. Supposing this, in this case, it was not there, that we made a mistake. We want to rectify it now. If this argument was not there from IOC, then the case would have been completely different with other things being the same.
Just, if I may just clarify, my lord, they have said it's a vigilance inquiry. They've gone ahead with punitive action
It's
against
internal vigilance.
True, my lord, but they have recommended, they on their own say, my lord, that we've recommended penalties for the persons who were involved as if it's a recruitment scam of sorts.
A mistake has been committed. We want to rectify it.
My lord.
Please allow us to do it, is what they are saying.
Right.
Tell us a reason why the court will say, no, you cannot do it. What you are saying is all miscellaneous things. A public sector undertaking is coming and saying is that, sorry, we have made a mistake. We should not have done this. But on receipt of a complaint, when we looked deeper into the matter, we found that there were anomalies. Our people are responsible for this. People who had better merit have been ousted wrongfully. We want to now restore the correct position here. We want to go ahead, please allow us. On what basis the court will say, sorry, you cannot go ahead. Even if you have made a mistake, people who were not eligible were appointed. Even if they were in probation period, we'll still not allow you. You have to give a very, very heavy reason for the court to do that.
Well, I'll try to show that it's all craft
You
because
try, but
initially-
only one chance.
True.
When do you want to take that chance? Date of chance, tell me.
My lord will have it in the second week of April. my lord. Or my lord,
If Mr. Chaudhary agrees, then only.
I don't have any problem. Let it be on 8th if it is not inconvenient.
Be on
Because-
10th.
10th.
But
Lord,
you have understood the
I've
issue
understood,
here.
I've-
You have
I've
to
got-
take it to that level.
my lord.
Otherwise, it's not going to work out. Again, I am repeating, a public sector undertaking is coming to the court and saying that we have made a mistake. Our officers have made a mistake. We were not aware of it. But when the complaint came, we looked into the matter, went further deep into the issue and found that there were anomalies. We want to now rectify it. But because of these proceedings, we are stuck up. Allow us to go ahead. The court has to say no to them to protect you. You have to have a very strong reason.
I'd show my lord that by the affidavit, they're trying to supplement because that was never the tenor, my lord. When I filed the writ, my lord, they tried.
Whatever. In Namkera, did you also work? No. Can you ask her to give the appearance?
Yes.
On the joint request of learned counsel for both the sides, let this matter be listed again on 10/4/2025 for hearing as fixed items.
Your lordship will keep it parted, that way we'll have the benefit of, it will come up higher, but your lordship has almost heard the matter.
Parted. Fixed parted. Fixed parted.
Okay.